Appellate Division 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court, if draw near to their attendance, and they shall be heard.
Please be seated. First case for argument is number 202, People versus Mohammed.
Good morning, Your Honors. I'd like first to turn to the issue of the defendant's right to a public trial. Our position is that the record in this case clearly shows that the defendant's right to a public trial was indeed violated. Whether explicitly or implicitly, the court officers at defendant's trial prevented spectators from entering the courtroom on the second day of witness testimony. Because of that, the victim's own mother, actually two mothers, one like a foster mother, was not able to watch the direct examination of the first witness for that day.
Counsel, can I ask you a question? Is this an all or nothing type of situation, or can there be some kind of a de minimis issue here? It was a short time that the courtroom was closed, or, and it wasn't done by the judge per se. Is there a time period that's acceptable, or is it not measured by that?
I'm not sure that the Court of Appeals has addressed that to say whether there is or there isn't, but in this case, it certainly would not be a de minimis or a trivial exclusion, because the witness who was testifying, for whose testimony the spectators were effectively excluded, was, in our review, the most critical witness in the trial.
There's no question it was critical testimony. I guess my question is, was the courtroom closed at the express direction of the judge?
The courtroom was closed at the direction of the judge, only in the sense that the judge had a policy of excluding spectator entrance while a witness is on the stand.
I think it's your contention, and you can correct me if I'm wrong, is you're not challenging that standing policy per se. You're not saying the court abuses discretion in limiting people from coming and going while the witness is on the stand. Your contention is that how that policy was administered by the court deputies in the hallway thereby violated your client's right to a public trial. It was what happened in the hallway by court personnel, not the court's policy that resulted in exclusion. Is that a fair summary?
That's correct. We're challenging just how this was implemented. The court did have a policy of excluding spectators during.
But you're not challenging that.
We're not challenging that, but it's relevant because we don't know why the court officer, Kelly Cummings, I believe was her name, we don't know why she effectively excluded spectators, but it seems that she thought there was someone on the witness stand and she couldn't let people come in.
It started, there was a lot of misunderstandings going on in the hallway. The first one seemed to start with a court officer assuming incorrectly that when Mr. Scott was brought in handcuffs on a material witness order, that somehow that wasn't open to the public. Because that's what the day started with him, correct? He was brought in. Now, he didn't testify until later, but he was brought in against his will. And it sounds like there was some misapprehension of that by the court deputies, that the courtroom shouldn't be open for that. Now, he didn't testify then. And then there was a matter with a juror who might have known one of the police officers. The jury wasn't there for that. And then the main witness came on. And so it sounded like what the court deputy said is, well, you can't come in while someone's on the stand people respected that when the witness, when there was a break, the court deputy never said, okay, you can come in now. And people didn't think they could come in. It was just a confluence of misunderstandings and mistakes that occurred outside the court's knowledge and consent. True?
Yes, I can't say, I can't speculate as to exactly what happened. I mean, there's some evidence to indicate what might have happened to cause this, but the important point I submit is not really what caused it, but rather that the witnesses were effectively, spectators were effectively excluded.
So what should have happened?
What
That
should
didn't
happen is, from the first, well, the video shows that between 9:06 and I think 9:28, 6 spectators checked their phones with Ms. Cummings, Officer Cummings. They should have been admitted.
Did
should
they,
have been admitted right then
is
and
there
there.
proof that they were excluded, that they were prohibited from entering at that time?
Well, Officer Cummings herself testified that she announced to spectators, it should be soon, let me check your phone so there's not a big rush. That's implicitly telling spectators that they can't enter.
But that was not at the court's direction, right? So
Yeah.
what you're asking us to hold is that the exclusion of spectators unilaterally by the court deputy is imputed to the judge.
Yes, on two related ways of looking at it is that the court officer is an officer or an agent of the court. So even though the judge himself presumably wouldn't have approved of this, what was going on in the courtroom, he was responsible for it ultimately because the officer is his agent. One case from the first department looked at in some respects, similar situation, and I didn't cite this in my brief, but it is a very apropos case that I just came across the other day, Moise, M-O-I-S-E, 110-83rd 49, where the court uses the language that the court officer usurped the judicial function. In effect, the court officer came to be acting as a judge and telling them, again, explicitly or implicitly, and there is some evidence for explicit exclusion, but at the very least implicit, she was communicating to the spectators that they could not enter at this time. When you say, give me your phones, so when it is time for you to come in, there won't be a big rush, you're effectively telling them that you can't come in now, but at a later time, you can come in. Well, that time didn't come until 10:15 or so, after the direct and part of the cross-examination of the most critical witness had already taken place.
So counsel, back to my original question, I wondered if, is there some kind of a time limit? Because my recollection is it was about 40 minutes of time that people were excluded or didn't come in or weren't permitted to come past that deputy to come into the courtroom. Is 41 minutes out of a trial that lasts days significant enough that we should grant a mistrial or overturn the conviction?
Yes, I submit that it is. I mean, I'm not aware of any case in which so significant and a period of exclusion has been deemed to be inconsequential. And again, it's if you get into that at all, and I submit that you shouldn't, I submit that any exclusion should require a new trial. But even if you do, this was a really important, critical witness. In fact, I have a whole point of my brief devoted to the examination of this witness. So this is just the type of thing that the right to a public trial is designed to ensure, that there is a public present in the courtroom who is watching a witness testify and perhaps could put some pressure on that witness to tell the truth. And
Counsel, I'm just going to advise you that you're getting very close on your time.
Okay, if I could, I'll just turn to,
Mr. Comer, excuse me one second. Here's what's troubling me. We look for error right here at the appellate division. So I don't know where the court committed an error here, nor is it preserved. That is, right at the get-go, the judge says, nobody can come in or out during the trial. It's not preserved because no one objected to it at that point. So without the policy having been objected to, any argument you have really is unpreserved and doesn't go all the way, correct?
Well, respectfully, Your Honor, we're not objecting to the policy per se. We're objecting to the implementation, the faulty implementation of that policy that resulted in the exclusion of spectators.
Well, without the policy, you have no action of the court where we can evaluate whether or not that was error.
Well, I respectfully submit that you do, and that you have the court's officers. An officer is really another word for an agent. The court's agents excluded the spectators.
That's your argument.
Time is up?
Well, that is your argument.
Okay.
And
Thank you.
actually, yeah, your time is also up, but I was saying that you've made that argument, yes, about the agency argument is
Yeah.
really your argument.
Okay, my time is up.
It is.
I would just, in closing, I'd ask you please to look carefully at the other arguments as well. Unfortunately, time here is brief, but all the arguments I submit are meritorious. Thank you.
Thank you.
Good morning, Your Honors. Ken Tyler for the people. I would submit to you this case is right somewhere near the nexus between Peterson and Cologne. Peterson being, it requires an affirmative act of the court for a defendant to say his constitutional right to a public trial has been abridged. Here, I would submit to you there's been no affirmative act by the court. Justice Lindley, I don't think, the court, I got to commend the county court for holding a lengthy fact-finding hearing, but I don't think I can disagree with you. This has just resulted from confluence of confusion by multiple parties.
Well, look, but for the court's policy, which appears to be unprecedented here, a standing policy, all my trials, he says, I don't allow anyone to enter or leave the courtroom while someone's on the stand. I looked long and hard. Any case I found from out of state said that policy, struck down that policy. If it weren't for that policy, but now counsel's not challenging the policy, but if it weren't for that policy, none of this would have happened. Mm-hmm. And that's an affirmative act. Nobody comes or goes. That's where I struggle a little bit. But as Justice Kern pointed out, there was no objection to the policy, and they're not even challenging it on appeal for some reason. So, as you say, we're left with the court deputy's implementation of the unchallenged policy.
Right, and you're speaking of Cologne, which is reasonable time and manner restrictions.
Jury select, or jury in charge.
And I'm aware of no jurisprudence saying in New York that that is per se improper, but more importantly, it's not even challenged here. Everybody affirmatively agreed below that that's an appropriate management administrative function of the court to have that policy. So with that, I'm not aware of an affirmative.
So the policy in Cologne, though, of course, was the policy was very different. It was not as expansive as the policy that this judge had, barring entry and exit or any entry during witness testimony. The policy in Cologne was just during the charge. A little more understandable than the policy here.
I can't disagree. This is going to necessarily be more expansive if the one in Cologne was limited to just the charge, and this one is every time a witness is getting on and off the stand or there's a break between, direct and cross. I can't disagree, but it's not challenged here.
Right.
That's kind of the reality of it. So I position this case somewhere between Peterson and Cologne. Justice Bannister, to your point, I just don't. I think an affirmative act is essential, and I understand that this is close to that, depending on how the issues were framed. But beyond that, the time period I would also submit is very close to Peterson. If you've reviewed the appellate division decision, there's multiple decisions in Peterson, but it looked like the period there was 20 to 30 minutes. Defendant was testifying in that. That would seem pretty important to me. And the court said, that was de minimis, insufficient to require relief on appeal for a closure issue. So I would ask you to affirm.
Thank you.
Thank you.
203, People versus Hearst. Morning.
Good morning, Your Honors. May it please the Court, Catherine Friedman, representing Appellant Michael Hurst. Your Honors, I'd like to rest on my brief, but before I do, I would just like you to consider the following 2 points. First, I'd like you to look at the complainant's testimony in light of the fact that she did have a serious mental illness, which according to defendant's expert existed prior to the horrific attack in 2018. And secondly, I'd also ask this court to consider the fact that there is absolutely no DNA evidence linking my client to that attack. And with that, I rest on my brief. If you have any questions, I'm more than happy to answer them.
Thank you.
Good morning, Your Honors. May it please the court, Ashley Lowry on behalf of the people. The trial court here fulfilled its gatekeeping function with respect to disclosure of the victim's confidential mental health records and prevented defense counsel's access to mere cross-examination fodder. Unless the court has any other questions, I will rest on my brief.
Thank you.
Thank you.
Number 204, People versus Pitts. Good morning, you may proceed.
Good morning, Your Honors. May it please the Court, Thomas Leith for the appellant, Mr. Jonathan Pitts. The issue in this case boils down to whether or not the 46 days for the people to produce grand jury minutes as requested by the defendant was reasonable.
Right.
There's no dispute that it took 5 months and 22 days for them to indict Mr. Pitts, and we agree with the people that the 8 days that it took them to file a certificate of compliance after January 1st of 2020 would not make the difference of itself. So getting to...
Let me just make sure I have the time frame right. So the people requested the minutes within 21 days of the defendant's motion, right? The defendant's request?
That's correct, Judge.
And the court received them 46 days after the defendant's motion. And so that's really the question, whether these timeframes are reasonable.
That's right, Judge. So the Court of Appeals under Harris clearly says that the time from which reasonableness begins, let's say, is the date that the defendant actually requests those minutes under 21030. And so it did take, and without a challenge to that request, which there was not here, that's the operative date. And so...
that's October 3rd of 19, October 3rd, 19. Does it matter under this reasonableness test of Harris, the jurisdiction you're in, the caseload, and how busy people are? Does that get factored in? In other words, would it be different in Onondaga where we are here as opposed to some rural county?
Well, Judge, I don't think that, I mean, it potentially could, of course, but I don't think that most counties in New York, everyone faces a backlog and resource problems. And this is a situation that's completely under the control of the prosecution, in the sense that they control the stenographers, they work for them, they can just send an email. And I think in a case like this, for that to take 3 weeks to happen after they're on notice, and also, you know, it took 5 months and 22 days to indict, and so they should have been more cautious then if it was just a question.
Right. So really, it's not the reasonableness isn't the time it took the stenographer to turn it around from the request. Because all you need here is, what, 9 or 10 days of time charge?
That's right.
And it sounds like you're on firmer ground with it wasn't reasonable to wait 21 days, 3 weeks to ask for them.
Yes,
So
that
you're
is
not
our...
really saying, because we don't know how busy the court stenographer, the grand jury stenographer was and so forth. That seems entirely reasonable. But I guess your stronger argument is, why wait 3 weeks when you get the request? Just make the request of the stenographer, and 3 weeks is not reasonable, so you win.
That is our argument, Judge, and especially in this day and age when it presumably requires an email to do. And of course, things happen, but this is the 3030 statute. This is the danger that the state got itself into when it took so long to indict in the first place. I think it's rather clear here. The excuses and the rationale come up with were, one, backlogs, and also the the defense filing the motion early, and they still, I don't see why that should matter, since they still have notice of it happening.
So you say 21 days is too long to ask this court stenographer. What is a reasonable period? Would it be a week, 10 days, 2 weeks?
I think, Judge, any delay beyond the date that they responded begins to be unreasonable, so those 3 weeks, so anywhere from October 24th until they finally did produce the minutes, which was,
Okay, well, now, I thought you were saying the unreasonableness was the prosecutor asking the stenographer for the minutes.
yes, yes, so something along a week is reasonable, of course.
So you're saying that any time that they appear for the argument date, they should have the grand jury minutes in hand already provided them to the court?
I think that that's a fair requirement of the state, or at least that they have asked for them well in advance of that and can produce a reason why
Do you have
this.
any case that says that that's the requirement?
Well, we have cases that talk about 36 days being unreasonable. We have cases from this department talking about 46 days
It's
being.
all fact-specific.
It is fact-specific, Judge, and it also depends on what the reasoning for not having those minutes produced. Now, you know, and to just perhaps push that back a little bit on Justice Lindley's point, it should be factored in how long it takes the stenographer to get the minutes, because they are a part of the prosecution in this scenario. And if they knew they were running up against the clock, presumably they have the authority to say, look, we need to do this one first. And so it's not as if it's completely out of the people's control in a case how long it takes the stenographer to produce those minutes.
Thank you.
You're welcome.
Good morning. May it please the court, Caitlin Guptill on behalf of the people. It's our position that the court correctly held that the people did not exceed the 6-month time in which they were required to be ready for trial. Specifically, the people provided the grand jury minutes in a timely fashion. I would note that defendant here filed their motions 2 weeks before the court's established schedule, and the people also responded before the return date that was provided for the court. We did request the minutes promptly from the stenographer, approximately 21 days from.
That's prompt for you?
Prompt in taking into consideration the schedule that was established by the court. And I think Justice Winslow mentioned that this analysis is fact-specific. And we discussed taking into consideration the caseloads that a particular county has. I did note that at the time, we, Onondaga County only had 3 stenographers per the judiciary law. I think that taking into consideration the shifted schedule and the caseload burdens, I think 21 days here was reasonable. And they were moving rather promptly. This case wasn't languishing on the court's schedule. I would point out that I don't think the Fourth Department or the Court of Appeals has demarcated an explicit time for what reasonableness is. I cited a number of cases in my brief indicating 36 days has been held to be reasonable in Harris, 32 days held to be reasonable in Cushman, 64 days was held to be reasonable in Eastwood, and in that case, the people were preparing a response to omnibus motions, similar to the case at hand here. I would respectfully submit that it's reasonable under all of the facts here, and unless the court has any further questions, I would rest on my brief.
Thank you.
Thank you.
205, People versus Goodwin. Good morning. You may proceed.
Good morning. May it please the court, my name is Mary Whiteside. I'm here for appellant Goodwin. Our position is that the court violated Mr. Goodwin's constitutional statutory right to counsel when it did not appoint him counsel at arraignment, although he was financially able. The court relied on the public defender's representations, which were in error, an error that they corrected.
How do we know, Ms. Whiteside, that the court was wrong when it didn't assign counsel at city court back on December 11th? Do we have
Well-
enough record on that?
Well, I think, you know, they relied on the public defender's representations. The public defender spoke with him before, and they represented to the court. So the court was relying on...
They represented that the defendant didn't qualify for it.
Correct, but that was an error, and the public defender is also...
how do we-
How do we know?
First, but I defer to you.
Yeah, how do we know that that's error? I guess that's Judge Kern's question. And isn't the court allowed to rely on the public defender's representation at that time?
Well, I think that the court is, okay, I know why
There's
there's
two
an error.
questions,
I know,
anyway.
the first part, I know why there's an error, but it's outside the record. I saw the public defenders, but it was outside the record, so I didn't include it. I mean, there was a misplaced comma in the amount of assets that he had. So they wrote down initially that he had far more assets than he really had. They corrected that, and you can see that they came when the grand jury, when they were going to call him again for grand jury. And I can go back through that timeline because it's crucial.
Look what that error cost the defendant. He had a immediate wish to appear before the grand jury, expressed it many times, and yet that error kept him from being able to testify when all the other testimony was coming in. Now, I know he then had a later opportunity and was possibly advised not to testify in front of a grand jury that has already indicted him, and that's probably good advice. But that error cost him the opportunity to do what he wished to do and made known from the very, very beginning.
Absolutely, Your Honor. And my contention is that the Public Defender's Office is a government entity, that it is, part of the court system, that this right that the client was denied is a fundamental constitutional right.
What's the city court judge, in this case Judge Castro, supposed to do? In arraignment, you may have 100 people coming in. If the public defender interviews the client or the defendant and tells the judge he doesn't qualify, does the judge then inquire on his or her own and say, well, tell me exactly how much money you have in the bank, where are you working, do you have any retirement accounts, let me see your tax returns? Is that a burden? That burden is just not feasible to impose on the court there. There seems to be not entirely unreasonable to delegate that to the public defender's office, because they know what the criteria are, who qualifies, who doesn't. Sounds like there was a mistake there, outside the record. I would say the mere fact that Mr. Windward later said that he qualified doesn't mean that he qualified earlier when he was before Judge Castro, because he's been in jail the whole time. He probably lost his job. But what are you asking us to tell the arraigning court to do anytime the public defender says he doesn't qualify?
Well, I do think that I do think that something is unfortunate. There is a missing transcript from the 15th. I do believe that from December 15th. I do believe that there was a further inquiry that unfortunately we're unable to see that inquiry. I mean, it appears by looking at the rest of the transcripts, it appears there was a court date. It's mentioned in motion papers. However, when when I asked for all the transcripts, I was unable to get that. There was no record of that.
Ms. Whiteside,
yes.
me again, just a further interruption.
So sorry.
I mean, I'm troubled by the fact that he was clearly unrepresented by counsel at the arraignment at city court and the purported invite to the grand jury where he's escorted down by the deputies to the grand jury. I don't think there's any dispute. There's no record of being represented then. He's not represented for about 25 days later.
Correct.
And yet, I don't know where the error is. And you haven't argued that the court failed to comply with its obligations, I see it under 18010, subdivision 4, where the court must take affirmative action to effectuate the rights, including the assignment of counsel. I personally think maybe the court needed to do more, but that's not the argument here. Aren't you better off on a 440 is my ultimate question.
Or maybe you would obtain the record that isn't before us at this time.
I mean, that's perhaps, I believe that there's enough record here to indicate. I also believe that it's
To indicate what?
To indicate that, the client did make these arguments and that the court did have an opportunity to inquire further before, and the client
I guess
acted.
My question is, what inquiry is required? Because we have to apply a rule here.
Sure.
And what would the rule be? How much inquiry does a judge have to do every single time somebody doesn't qualify?
Well, I think that they could make a cursory inquiry as to, their employment, as to into assets, into their ability to afford to retain counsel, and could give the defendant the opportunity to say, I can't retain counsel, and then the court could appoint
so you say
722D.
You say the court could do that. Is the court required to do that, I guess is my question.
Well, I think ultimately the court is required to protect the client's right to counsel at every single critical stage. And the fact pattern in this case is clear that this was the very critical stage of this case, and that he was unrepresented through that, and that he had to act pro se,
Well, the
which he
information
did.
the court had was that this individual did not qualify for the services of the public defender. And if the person was within that range, but there was a conflict, you would imagine that the public defender would have told the judge that, and then the judge would have assigned someone 722D. But if the judge thinks that this is someone who can afford counsel, then they're not going to appoint someone 722D. They're going to expect that person to retain counsel.
Understood, but I think that the client then is asked to bear the full cost of their deprivation of their right to counsel when they are indigent. And a government entity, the Public Defender's Office, made a crucial error, which the court is relying on. That is a procedure that the court has set up with the Public Defender's Office, and the taking that away and not holding any of the government entities responsible for that results in the client, the person whose rights are supposed to be protected.
Your strongest argument that it was a mistake, I'm sorry again, but your strongest argument that it was a mistake was, first, they let him speak to a public defender apparently on December 23rd or thereabouts, and then they provided him one back on January 5 or 6, whatever the day the agreement. So that's your strongest argument. So it looks like he was not given counsel when he was deserving of it.
Correct. He was not given counsel when he was deserving of it. And the Public Defender's Office, in my opinion, should have, at that point, made it very clear that they made an error, should have called the conflict, and gotten out of the case, and so that counsel could have come in and addressed that right away. And they didn't do that, and I don't understand why, but they did not. And I think that would have clarified things. Instead, they continued on with representation. In my opinion, that he was essentially unrepresented for an additional 125 days, while they continued to represent him, refusing to file a 19050 motion, which he requested.
Well, wasn't it because they adjourned the matter for a couple of months because they were considering judicial diversion, whether he was eligible or not, and so they probably thought maybe this thing will work out by itself and we don't need to do all of that?
I mean, I think you're probably right, but the client, immediately said they wanted to file the 19050 motion, and the Public Defender's Office said, well, we can't do that from our office. They should have immediately should have filed the conflict at that point, and then when it came down to motions being filed, the client, people retained an attorney for him, and then that motion was immediately filed, and he immediately addressed this issue, which had been the issue for him from the beginning of the case. So I think he's been very clear about that and trying to assert his rights as best he could throughout this process. And so I'd just ask this court to not hold him responsible for the actions of the government, which deprived him of his fundamental right, and I'd ask you to dismiss the indictment.
Thank you.
Good morning, Your Honors. Derek Harnsberger on behalf of the people. As this panel has astutely...
Your first point, Mr. Harnsberger, your brief that I'm looking at now, is that the local court properly declined to assign the public defender a defendant's arraignment. That's your position?
Yes, Judge.
How is it then he ends up with being escorted by the deputies? How does that work? Down to the grand jury, and then all of a sudden the public defender appears? And then all of a sudden the public defender appears on January 6th? How does all that happen, sir? And yet to stick up with your point.
And this is one of the problems with the instant record, and this goes to the contention that this panel has brought up several times, is the record here really does not lay out. For example, when counsel is saying they're not eligible, this whole idea that the counsel was not assigned in the first place was because he was not eligible, because of error. The fact of the matter is there is no record support that there was error mathematically.
Isn't the error demonstrated by the fact that a public defender apparently was provided to him when he's escorted by the deputies without the auspices of the court to come down to the grand jury, and then all of a sudden a public defender shows up on January 5 and says, yes, he's eligible? Isn't that evidence of the error?
See, this is the difficult part, is we're really diving into speculation as to what occurred there, because for all intents and purposes, it could...
Isn't your answer that somebody could be eligible at the first court date when they're arraigned, because they have a job? If they're held in custody, then a month or so later, they don't have money anymore, and they become eligible. People can become eligible who were not otherwise eligible. Now, it sounds like, from what she's saying outside the record, he was eligible the whole time, but there are, more often than not, when the public defender says somebody's not eligible, they're not eligible. And the question is, what is the court supposed to do to ensure that information is accurate?
And you're absolutely correct, Justice Lilly, that I'm trying to hit two different points in two different areas here. To your point, Judge Lilly, before I forget, and I'll get to you in a second, Justice Kern, I wholeheartedly agree that there are situations in which, particularly if a person has assets at arraignment, or there is a mingling with other assets of other individuals, say an individual is married and we're looking at individual assets, but yet they're separated. There are situations where there could be an evaluation initially where they're determined to be ineligible, and then they're subsequently evaluated later and determined to be eligible, including but not limited to liquidating assets or transferring assets or making clear where there's an ambiguity. To Justice Kern's point, the issue here is that we truly don't know what spawned the public defender to show up in grand jury.
But your first point is that it was legally proper, and it seems to me you've taken on the burden, probably rightfully so, to establish that the declination of assigned counsel at the very first arraignment was proper. Don't you have an insufficient record to establish that?
It's, Your Honor, I believe that, as I don't remember which justice pointed it out, but the court has to rely upon the record of the public defender. When the public defender conducts their investigation and reports to the court that they were
This is where I have
ineligible.
a slight difference. I don't know if it's argued here. 180.10, as you know, says here's what you have to do at arraignment. Offer an adjournment to get counsel, and to have counsel assigned. That's two of the three. And the court must inform the defendant of all those rights. And the court must accord the defendant opportunity to exercise those rights, and must itself take such affirmative action as is necessary to effectuate them. I see here the court did absolutely nothing to question the defendant. Hey, is that right that you can't afford counsel, or that you can't afford counsel? Don't you agree the court should have done more here?
It's, Your Honor, I would say in this case that the court is relying upon the expertise and the time that the public defender put in, and they have to rely as an institutional matter.
Counsel, the way it works is that the public defender's office has a representative go in, and all they do is eligibility information with people that are going to be arraigned. They provide that information to a public defender who's an officer of the court, who then stands in front of the court, and as an officer of the court states whether or not the person has been found eligible by their office or not. If the person's been found ineligible by their office, the judge doesn't assign them to represent that person.
Absolutely.
And we just don't have a record to know what the minutia of that finding of ineligibility is.
Correct.
But
And
here's where the error, if there was an error, and it's easy with the benefit of a transcript in time to say you should have done this, should have done that, but I don't fault the court for not questioning his eligibility at the first court date. But when the defendant comes back, what is it, 4 or 5 days later for his PH, he's already been indicted by then. He still doesn't have a lawyer. The case gets waived to the grand jury. It seems to me that the customary practice usually is, now maybe it's unnecessary, is you inquire, okay, you're not eligible, did you make any efforts to hire a lawyer? Who did you call? Do you have anyone on the outside? You need a lawyer. You make some inquiries there. What have you done to try to get a lawyer? Because you're not eligible for a free one. The defendant, then there's some back and forth. Usually what then happens is the court will appoint somebody to represent the defendant under county law section 22D, which means the guy still has to pay for it. The county's going to send him a bill. You're not eligible for a free lawyer, but you need a lawyer. I'm going to assign somebody to represent you, Mr. Smith, and then Mr. Smith's going to send a bill to the county, and the county is then going to send a bill to you. It seems unusual for a local court judge to just send somebody to waive it to county court on an indictment still unrepresented, knowing that the arraignment could be sometime later. So he's sitting there in jail. That seems to me to be the more troublesome part of this.
well, and I think to that point, Your Honor, that there's, and counsel hinted at this, and it's, an issue where when the court initially adjourned the case, it was on the 11th the defendant appeared, and the court adjourned it to the 15th for the notice date for grand jury, and then there was a preliminary hearing date set for the following day on the 16th.
It's
For
the
what-
opposite, sir, I think.
For-
The 11th was a Friday, that's when he's arraigned. The grand jury's going to meet at 2:30 PM on the 15th. The preliminary hearing is on the 16th. When the defendant arrives there, of course, the local court has lost jurisdiction
Correct.
by virtue of the indictment. So that's what happened. But then when he's brought down to the grand jury, and all of a sudden, miraculously, there's a public defender there. If we conclude that he was deprived of counsel at that critical stage, isn't the indictment to be dismissed?
Your Honor, keep in mind that I would assert that actually, I mean, if we're going to speculate as to how that attorney got there, I mean, we're going
We
way
can't
outside.
speculate, we don't have a record.
We don't have a record. I would assert
The
that.
DA now
we
knows
just-
that the grand
D-
jury has voted, has been informed that the defendant wrote a letter, and now has a letter after the vote, and knows that they have the requirement to allow that person to testify, so schedules it, has him brought over from the jail. You don't know if the DA went to the Part 1 county court judge and requested that someone be assigned. You don't know if the DA went out in the hall and found someone who was a public defender and asked them if they would do this. We have no way of knowing how this occurred.
And
We have
that's,
no way of knowing if it actually occurred at all. It's just.
we just literally do not know on this record, and to the point that this is appropriate for 440, that would seem very appropriate, but for direct appeal based on this record, I don't think the court can get there. So, thank you very much, Your Honor.
Thank you. 206, Dutton versus Young Men's Christian Association. You may proceed.
Good morning, Your Honors. Brenda Harkavy on behalf of Plaintiff Appellant Roger Dutton. It is our position that a de facto merger occurred between the YMCA Buffalo and YMCA Niagara.
Or at least that there's a question of fact on that question.
That is correct, Your Honor.
Let me follow up on that, Sir. Justice presiding, by question of fact. So this would be something that had to be determined by a jury?
Whether or not a de facto merger occurred?
Right.
Well,
I'm trying to come up with a jury instruction in my head. How this gets resolved.
well, respectfully, Your
I know
Honor.
that's for another day,
Yes,
perhaps.
it could also be determined on a motion for summary judgment that we would feasibly be able to file if the case was
Well, but
reversed.
This was a motion to dismiss.
That is correct, Your Honor.
And what the court said is the doctrine doesn't apply here, couldn't apply here under these facts, so it didn't exercise its discretion considering all these factors. So if we were to reverse, it doesn't mean that we're saying that it applies. We're saying you get a chance to argue that it applies on a summary judgment motion. And then if you survive that, it could go to trial. So we're 2 steps removed from trial. This is just, could it possibly, under these facts, under the complaint, apply? Trial court said no, you say yes. Doesn't mean that you're going to win on summary judgment, though. Correct?
Yes, that is true, Justice Lindley, but I
And
would.
to follow up on that, it looks to me like the Supreme Court basically focused on the idea that there was an intermediary in the transfer of title. And basically that disqualifies the doctrine. And you've argued, no, that's not true, I think in part because we have 1 or 2 cases, it begins with an L.
It's Lippens.
Thank you,
Lippens.
Lawson,
Swetland.
where they went through a bankruptcy apparently. So there's an intermediary. But I'm looking at the not-for-profit corporation law. It looks like it has to go to USA, right?
Yes,
If that's true, don't the liabilities get transferred to USA first? And then given the transfer to Buffalo, they didn't take on any of those liabilities. So where are you going with this?
so, Your Honor, first and foremost, under the de facto merger doctrine, it's a merger, but the parties stepped around the statutory requirements. And the party which assumes the benefits of that merger, which are, in this case, the assets, the facilities, continuation of the operations, and actually making a Niagara branch one of the Buffalo branches, they become responsible for the good with the bad, frankly. And so they become responsible for all of the liabilities as though this were a merger under the statute. And under the nonprofit corporation law, that would be the
If
case.
this was, and I understand, if you purchase assets from another business, then you accept the good with the bad. Here, those assets were losing money, and that's why The YMCA Niagara went out of business. There was no good here. And the other side says that there's no cases, and you haven't cited any cases where the de facto merger doctrine applied, where a not-for-profit corporation was dissolved by a court. And that's a fundamentally different situation than most other situations where there's one business that acquires assets from another. That's not what happened here. The Niagara Falls YMCA was dissolved judicially because it was losing money, hemorrhaging money. So the Buffalo YMCA took it over. There's no good there for the Buffalo. They're just absorbing facilities that are running at a loss.
And respectfully, I would disagree with that. First and foremost, they obtained 2 properties. They were able to retain all the membership. They were able to retain the trademarks, all of the assets, buildings, know-how. And if this were just a standard dissolution, why is it that there was an agreement that the board of directors and board of trustees of the dissolved entity, it had to be agreed on that they would come over? And I would note that while I understand your point that this was a dissolution by statute, I'd also note that under de facto merger, this is a flexible doctrine. And we have to look at the intent of the parties. And as was noted in our complaint and cited in footnotes, this was the result of failed merger negotiations, which the membership voted against the merger. And so this was a step around that was created in order to combine the entities, and the only way they could do that was through a dissolution because that's what the statute mandates.
Here's what I'm stuck on. Maybe it's not pertinent on a motion to dismiss. It could be relevant to summary judgment. I'm not sure yet in my own head here. But if you ignore the intermediary, right, then it's a transfer from Niagara to Buffalo. But that transfer document says they're not taking the liabilities. If we do the other and say, yes, there was an intermediary, albeit a token one, then it seems to me the liabilities are still with USA because the dissolved corporation could still be sued, so theoretically you could go after them, or you can go after USA. Under either theory, I don't see how you end up with Buffalo.
So under the merger doctrine, and this should be treated as though it's a merger, the successor entity, and in this case the successor, the entity that obtained the benefit, wasn't the USA, which was merely a procedural stepping stone. The entity that obtained the benefits was the successor, which is the YMCA of Buffalo.
So you treat it as a transfer from Niagara to Buffalo.
Yes, and I would note respectfully, Your Honor, in Justice Chimes's opinion, she actually made a misstatement. She stated that on the December 1st, 2005 transfer assignment and assumption agreement, that it was between YMCA Buffalo and YMCA of the USA. I would ask Your Honors to actually look at the record. The YMCA Niagara, YMCA Buffalo, and YMCA of the USA all signed that agreement.
So be it, but if it is a transfer from Niagara to Buffalo, and this is where I'm stuck on your argument, then the transfer agreement is as though it was with Niagara, and they didn't assume, Buffalo being they, didn't assume the liabilities, correct?
That doesn't matter under the de facto merger doctrine.
The de facto merger doctrine can countermand the agreement between the parties?
100%. There's actually case law and I'll cite a case from the Third Department. It's Wensing versus Paris Industries, where there was actually a court that held that liabilities would not transfer, and there was the 1978 Federal Bankruptcy Act, which actually held that an entity that obtained the successor entity would not be liable for the torts of the predecessor. And the court found that the ruling court, the Third Department, found that even an order from a court upholding an agreement related to liabilities could not override the de facto merger theory because it's rooted in equity, and the parties to a contract can affect their own rights, but not the rights of a third party, which was stated in Grant Howard and in Lipin's cases.
Well, it seems to me that if a party expressly declines to assume the liabilities, it seems to me that if we were to say that defeats the de facto merger, we'd be kind of going against Schumacher.
Then the doctrine would never apply. I mean, you would always just say that, but here, policy-wise, again, we have not-for-profit organization that was dissolved because it was not profitable. If if the doctrine applies, and therefore the Buffalo YMCA is on the hook for the alleged sexual abuse that occurred decades ago, it's going to discourage nonprofit organizations like the Buffalo YMCA from taking over, merging, if you will, with unprofitable organizations out of fear that somebody at some point next year, 20, 30 years from now is going to come out of the woodwork and say, I was abused as a child.
So the point, though, of de facto merger is it's a case-by-case flexible doctrine. And I would note, Your Honor, that in this case, we have very specific facts where the parties really used this as a workaround to be able to merge. And if an entity was...
You've said that, this is kind of a unique fact pattern to be, the de facto merger doctrine. I mean, every case that I think I've ever seen it is usually a products liability case. So this is kind of a unique factual situation to be applying the doctrine.
It is, except in de facto merger is based on that. You have to look at the facts and the substance, and is the party reaping a benefit without taking on the liabilities that they would be required to take on had they worked through the regular statutory mandates. And in response to Justice Lindley's question, if you're any entity that would have gone through a regular statutory merger automatically is liable for the predecessor entities.
Right, but I guess what you're saying is that you're not asking us to say that the doctrine applies. You're not asking us to consider any of these policy considerations. You just want an opportunity to make the argument to the trial court, because the trial court dismissed it 32-11. You want your shot so the court can consider all the factors. You might win or you might lose, but you're not asking us to say it applies. You're just asking us to say that it could possibly apply.
We haven't had the benefit of discovery. We don't know. The only things that were produced here were documentary evidence produced by the defendants. They're the ones who handpicked.
Just so I'm clear, to follow up on Justice Lindley, you're saying that we do not have to decide now that, in fact, this doctrine applies to these facts, correct?
We're just asking you to reverse the lower court's opinion at this point in time.
Right, and kind of circling back to the beginning of your argument, I know I stated that there's a question of fact, but you're right, this is a 32-11 motion, so really, more properly, we would be saying you've stated a cause of action if we agree with you.
Right, that's correct.
We have your argument.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. Ryan Lima on behalf of the respondent, YMCA Buffalo Niagara. The trial court properly determined that the de facto merger doctrine could not apply under these facts as a matter of law. Going back to the Court of Appeals,
Your main argument, it seems to me, is that there's this intermediary.
I don't think so. I think that the intermediary idea, I think, somewhat misrepresents the YMCA's argument. The fact that the YUSA here was an intermediary is relevant but not dispositive. The point is that all of the de facto merger case law is applied in the context of an asset purchase transaction. Going back to the Schumacher opinion, all of the cases cited speak in terms of the liabilities transferring from the seller to the purchaser. And of course, to Justice Lindley's point, that's not what we had here. We have the dissolution of an entity and its assets then
For example, Schumacher, in some of the prior de facto merger cases, arguments are made that the successor corporation has not assumed the liabilities. And that's the argument that you're making here, but under de facto merger, as your opponent has said, it's an equitable doctrine where you end up being charged with the liabilities.
It's a flexible doctrine insofar as we're talking about getting to the point where we apply those four factors as to whether or not it might apply. We don't even get to that stage because we don't have an asset purchase transaction here. The doctrine is wholly inapplicable under the circumstances.
Follow up on that. So, Justice Perodato covered this with your counterpart, but thinking about it more, we're on a 32-11 motion. You moved under A1 and A7. As I understand your argument now in response to Justice Perodato's question is, you're arguing A7, that is, they have not stated a cause of action because there's this intermediary that they haven't accounted for. That's one thing. Are you also under 3211A1, and if so, what's the documentary evidence? And if it's the transfer agreement, isn't your counterpoint right that doesn't do you any good on the doctrine? So kind of break it out for me in the context of A1 and A7, if you might please, for me.
Sure. Under A1, the documentary evidence is the corporate formation and dissolution documents, which establish that we're dealing with two separate entities, and what happened here was not an asset purchase transaction, but a statutory dissolution, and pursuant to the court order in the not-for-profit corporation law, when YMCA Niagara dissolves, its assets have to be distributed to another charitable tax-exempt organization with a similar purpose. Here, the statute specifically dictates Y of the USA, who then...
That dissolution document among the parties, that might be your Achilles heel. It basically says that it's got to go to Buffalo. So that may not be your strongest argument. Then you switch to A7. I think in response to Justice Paradaro's question, you're focusing on the intermediary. What else do you have under A7 that says that the plaintiff didn't state a cause of action for this merger doctrine?
I mean, primarily the argument that was made below on A7, which ultimately the court decided it under A1, was that in terms of simply pleading the application of the de facto merger doctrine, what the complaint actually says is, in conclusory fashion, that YMCA Buffalo and YMCA Niagara merged or underwent a de facto merger, and then there's almost a single paragraph of the complaint that recites out what the elements of a de facto merger are. And under the case law, that's simply not sufficient to state a cause of action for purposes of A7.
I understood one of your arguments, not your own one. Your one argument is that the de facto merger document applies only if there's a purchase of assets.
Yes.
And here, and that's what the judge below said in her decision.
Correct.
At one point. She said one of the prerequisites is a purchase of assets. Here, you're saying YMCA in Buffalo didn't purchase anything from the YMCA that was dissolved in Niagara. They just took over their operations because they were defunct.
Correct.
There was no money that changed hands, and therefore the doctrine doesn't apply in this situation. Am I getting you right on that?
That's right.
They got all the assets, though. They took over all the assets.
They did.
Without paying anything for them.
But you're correct, not as part of a purchase transaction. And getting back to the fundamental rationale and purpose for the de facto merger doctrine, what this court has said in Swetland and in Lippens is that the doctrine's purpose is so in asset purchase transactions where you have parties who are potentially ongoing businesses seeking to avoid liabilities by transferring operations from one entity to another, that this doctrine protects tort claimants. And so it's designed to detect what is in substance a merger that has been structured as an asset purchase transaction. That's far afield from the circumstances here. We have an entity that wound up its operations and dissolved, and those assets pursuant to statute had to be distributed somewhere else. YMCA Buffalo winds up with them. But the statute is clear as to what happens with the assets and liabilities of the dissolving corporation. Pursuant to that whole dissolution process, the liabilities are not transferred to the entity that receives those assets. And again, to your point, Justice Lindley, to hold so would have a chilling effect on any not-for-profit corporation that might receive the assets of another dissolving not-for-profit.
Well, that's a factor the trial court can consider if we reverse. That's a factor the trial court consider in deciding whether to apply the merger doctrine.
Well, this is a little more conceptual, but building onto that concept, to me anyways. So, looking down the road, if this case goes on, is it all of the Buffalo's assets that are subject to being, to a judgment for the plaintiff, or is it just what you got from Niagara? And the only reason I bring that up now is, maybe that's the value of looking at this, that you must have an asset purchase, because if you didn't give something for value for it, you just took it on, maybe that's a counter to applying the doctrine. I'm not sure that made sense, but it did to me. But do you see what I'm saying? If they can get at all your assets, and you didn't pay any, you didn't value this asset, but now you subjected everything you own to this judgment, doesn't that counter the application of this equitable doctrine?
It should. I mean, as I understand the doctrine, it simply would apply to transfer liability from one entity to another without regard to whether there's recovery against specific identifiable assets that maybe came from the dissolved corporation. If the court has no other questions, I'll rest on my right.
Thank you.
Thank you.
207, Ellen Field versus Kingsbury. You may proceed.
Good morning, Your Honors. May it please the Court, my name is Josh Dubs from Webster and Dubs, BC, representing the appellant. Your Honors, this case is a very straightforward one about a basic legal concept. Just despite all of the tangential arguments thrown about by the respondent as red herrings to confuse the court, the simple fact that 79 Covington Drive in West Seneca became the legal property of the appellant upon the decedent's death and the probate of his last will and testament. The executor of that estate had no more right to transfer Covington Drive to the respondents than I would have to transfer any of your honor's houses to the respondents.
Well, the executor, correct me if I'm wrong, the executor could do it, sell it, but needed a court order, needed an order from the surrogate.
That's correct, Your Honor.
And they didn't have one here.
That's correct, Your
So what
Honor.
it comes down to then is consent. Is consent another basis to sell property if the party who owns the property says, go ahead and sell it, and you don't have an order from the surrogate? Is that a valid, lawful reason to sell the property?
No, Your Honor, I would argue not. I mean, for starters, that would be violative of the statute of frauds. There needs to be some sort of writing under signature in order to successfully transfer the property. A lot of time was spent in the lower court during examinations before trial and in briefs talking about the fact that emails were being exchanged in which the appellant allegedly just simply did not object.
Well, she clearly wanted the property to be sold, and she wanted to get her money out of it. I mean, that's pretty clear from those emails. Would you agree that the obligations of the estate far exceeded the assets? The estate with the funeral expenses and so forth was over $17,000. The cash available to the estate after they sold the car was about $6,300. So there's a problem there. I guess what you're saying is that the executor, to address that problem, needs to go to the judge and say, can we sell the house to pay for these obligations of the estate?
I would respectfully disagree with Your Honor's interpretation of the emails. Again, it's more the executor saying, I'm going to do this, and the appellant basically, saying, okay.
Agreed, her attorneys agreed.
Well, I'm not sure, again, I'm not sure that, well, for starters, one of the attorneys, as was mentioned in the EBT, never actually was representing. The other one, again, was also basically said, oh, okay, well, I guess he's going to sell this, and never really were given the opportunity to formally object.
She has two attorneys that she's complaining about, that she contacted and were representing her. And they said, go ahead and sell it. And your client now seems to be blaming both of her attorneys for that. Maybe that's a separate action, but the executor's got two lawyers purportedly acting on behalf of your client saying, yeah, go ahead. And what's the executor to do?
Well, again, what's the executor to do, Your Honor? Could have secured my client's signature on the deed, or in the event that there was no agreement, could have petitioned to the surrogate for advice and direction and permission to sell the property. And it's worth noting, Your Honors, there was some talk about this in respondent's brief, that there actually is a motion pending before Surrogate Mosey right now for retroactive permission to do what the executor did here.
Correct.
So it's telling to me, Your Honors, that it appears that the executor recognizes that he shouldn't have done it this way and is now trying to clean it up.
I agree.
The fundamental point, though, Your Honor, is and this is why I feel this is such a basic concept. Again, the case law is very clear that the property title transferred upon death. So the transfer of the property, or the alleged transfer of the property by the executor, is a nullity because he never had the ability to sell it.
Yeah, you make that point well in your brief. Now, how about the issue of the defendants? You didn't sue the executor.
Correct.
Your client didn't sue the executor. He's the one who allegedly acted improperly. You are suing the parties who purchased, the good faith, bona fide purchasers who purchased it from the executor, and now you want to take their property from them. And as a result of this, your client would get a huge windfall because she wouldn't even have to pay the mortgage. She's going to end up with the house free and clear, whereas if it went the way you wanted it, she would have gotten the house and the mortgage and just a little bit of equity. How is, these defendants, you would acknowledge that the defendants you sued did nothing wrong?
Other than not, they're the defendants themselves? No.
Yes,
The
they did
counsel,
nothing
the
wrong.
title
They just-
examiner perhaps, but
They bought a house, they didn't engage in any misconduct, they're the only defendants here.
sure.
They were bona fide purchasers for value, arm's length transaction. and now you want to take their house.
Well, Your Honor, I would respond to that in two ways. Again, because title vested in the appellant upon the death of the executor, essentially, we're asking the court to give the house back. It's not that we're trying to take somebody else's house, it's that somebody else is claiming title to her house. With respect to the status as bona fide purchaser for value, the case that is cited by both myself and by Respondent's Counsel is the SRP case, which was out of this court in the Fourth Department. However, the Respondent's status as a bona fide purchaser for value fails on the third prong, because to have that, you need to be without actual or record notice of another party's adverse interests. As we sent, as we cited.
How were these purchasers supposed to be on notice?
Well, Your Honor, the estate was the seller. Okay, the seller was the estate. The respondent very wisely purchased a fee title policy to this. Okay, and that came as a result of a title examination, which was constructively on notice that the estate had an interest. The fact that the title examiner missed it perhaps is a claim that somebody could bring against.
Missed what?
I'm sorry, Judge?
What did they miss?
They missed the fact that the estate was the seller and that there was a specific devise in that last will and testament giving that property.
That means they're supposed to get a copy of the will?
The copy of the will is available. The estate was open.
Well, that doesn't answer the question.
I'm sorry?
Are they required, when they're purchasing, when someone's purchasing property from the estate, are they required to go back to the will?
Yes, Your Honor, they are. They're supposed to do their due diligence.
So that's what these defendants should have done.
Well, that's what the representatives of the defendant should have done. Certainly, you know, a non-attorney, non-title examiner wouldn't know to do that. But again, they got a title examination. They got a fee policy. That should have been a notation in the fee policy that there was something there giving somebody else an interest in the property. We don't know if it was missed or if it was done, but they sold the property anyway. And in either event, it was missed that the property didn't actually belong to the executor, or excuse me, to the estate, and the executor had no
Well, didn't the
right.
executor effectively serve as your client's agent based on her consent to sell?
Again, Your Honor, I dispute my client consented to sell. Again, this really, the emails represent the executor saying, we're going to sell this. You can't afford it. We're just going to sell it. We're going to give you the money. And my client, who is, as the respondent, an unsophisticated actor in this matter, basically shirks back and says, okay, I guess if that's what you got to do.
So let me just backtrack. Let's assume that the executor had not skipped the step of going to the surrogate for permission. It seems to me the surrogate likely would have granted permission because the proceeds from the sale of the house were needed to pay the obligations of the estate, other than the mortgage. And so the surrogate grants permission, the house gets sold. When the property is sold, the mortgage has to be satisfied. So it seems to me your client would have been in the same position.
Maybe, maybe not, Your Honor. Okay, it's worth noting that two of the largest obligations of the estate, other than the mortgage, are the attorney's fees and the executor's commissions, both of which are calculated as a percentage. The attorneys are also requesting from surrogate Mosey attorney's fees that are equal to the amount of the executor's commissions. And both of those are calculated with 79 Covington Drive listed as an asset of the estate. So you remove that asset from the estate and give it to my client, as it was supposed to happen. Many of the obligations of the estate go away, and the amount that is due shrinks.
Your client, there was a $50,000 loan to Home Depot.
Right.
And based on all this, after your client had all these problems, Home Depot just wrote that off.
Correct.
So your client benefited to the tune of 50 grand because of all this.
Well, I'm not sure, I mean, I don't believe it was ever explained why Home Depot did what they did. So that's really sort of outside the issues at hand. I don't know whether or not they would have put a claim against the estate, because remember, I believe it was a joint debt of the estate and of my client.
If we were to reverse, there's a pending motion before the surrogate non-proton to approve in retrospect this order. sounds like the surrogate's holding off until we decide. But it doesn't seem like, even if we were to reverse, it seems like that's going to happen and it's all for naught. Because
Again-
as Justice Peredato said, there's clearly a basis for the surrogate to have ordered the sale.
Possibly, Your Honor. Again, without having the citation there, without having the opportunity to conduct any discovery under Surrogate Court Procedure Act's Article 22 or anything like that, essentially we won't know. It is certainly true that Surrogate Mosey could very well order this and make this whole issue moot. But again, that's something that will have to be addressed in the surrogate's court. It never was. The house was simply
No,
sold.
we understand that. I think we understand. I think we have your argument, counsel.
Thank you, Your Honors.
Good morning, Your Honors. May it please the Court. Vanessa Elliott with Fidelity National Law Group. I'm here on behalf of the defendants' respondents Jason Kingsbury and Maureen Moran. And we would respectfully submit that they are bona fide purchasers for value. They had no knowledge that there was any objection to the sale. Ms. Ellenfield requested the sale to occur. She asked for the mortgage to be paid off for the proceeds. She knew of the sale date. She had attorneys involved. She never made any objection. Her attorneys never made any objection to the sale.
She was referred to as an unsophisticated actor, but yet she was the person who, a day after the decedent died, contacted the executor about selling the property and had already consulted with realtors, named a price of $115,000. The executor managed to sell it for $125,000. She consulted two attorneys, not quite the normal definition of unsophisticated.
Yes, Your Honor, absolutely.
yeah.
She was quite interested in selling the property, and she had attorneys representing her at every step of the way.
So your argument is that even if the executor acted without authority in selling it to your client's status as bona fide purchasers for value, the case should be dismissed against them for that reason. Let them go after the executor if they want to.
Yes, Your Honor, that's our alternative argument. I think that the facts of this case really drive the answer, and the correct answer was found by Supreme Court, and that's based on Ms. Ellenfield's own testimony, on her own emails, on her own texts, on her attorney's letters, on her admissions and deposition that she went over the accounting and she actually agreed to it post-sale, on her request that the proceeds be paid out to her as soon as possible. I mean, at every turn, Ms. Ellenfield requested and consented, acquiesced, and confirmed post-sale that this is what she wanted to happen.
Your argument today seems to be a little bit different than your brief.
No, Your Honor, I believe...
I didn't think you argued consent. I just thought you argued they didn't need a court order.
Yeah, well, Your Honor, it's twofold. I believe consent is my primary argument, that she requested and agreed and accepted and wanted this to happen. So and her attorneys also did, and the attorneys discussed it and agreed that this was the best way for it to proceed. But in addition, it was also the executor was authorized to do it because there were funeral expenses and there were debts that he had to pay apart from the mortgage, which was outside of the estate.
But he needed a court order to do that. The executor wasn't authorized to do it without a court order.
Well, I believe the court order can be done non-pro-tunc. I
Okay?
think that the
Either way-
facts drive
either way,
it more
you
than
need
the
a
court order.
Either way, you need a court order. You're saying, well, we don't need one here because she consented. Are there any cases that you could find or cite that say that consent is an exception to the requirement you need a court order from the surrogate?
Yes, Your Honor, and particularly where you have third parties relying upon her quietude, her consent, her acquiescence. She was fully aware.
What cases are those that you found?
I believe they're cited in my brief, where there's...
Well, I'll find them, and I didn't see.
We have third parties where third parties are damaged by the transaction that was authorized, that was supported by the circumstances that the executor had the authority, prior to a court order, the executor has the factual basis for acting with regard to the property because of the non-liquidity of the estate. That when a third party is damaged by that transaction, is involved, that the third party should not be left to be damaged, left to be harmed by that transaction, that the action on the part of the devisees is against the executor, it's against the estate, it's against the proceeds of the sale, not against the party that has now paid off the mortgage and improved the property to their great detriment. It's their home, they put a new roof on the house, they've redone the wiring, they've put in new toilets, they've made this house into something that it was not prior to the sale. And these third parties, as bona fide purchasers, should not be held to account for the plaintiff's post-sale decision to challenge the technical aspects of the sale.
Okay, I think we have your argument.
Thank you.
Thank you. 208, Gonzalez versus McCarver. Good morning, Mr. Ryan, you may proceed.
Good morning, Your Honors, and may it please the Court. Your Honors, this trial court order requires reversal and entering judgment in favor of the plaintiffs because there was no cessation of treatment with the plaintiff, Alexis Gonzalez. I would refer...
Mr. Ryan,
Yep.
just on that point, I thought I read your brief that basically says you just want the cross motion to be denied and to have a trial on serious injury.
I believe that a first point, Your Honor, is that the serious injury threshold in the brief, that the serious injury threshold motion that we made should still be granted because it was unopposed by any sort of expert opinion.
But they don't really need an expert to point out a gap in treatment for your own client, correct?
I agree with that, Your Honor. That's if a gap in treatment exists. Your Honors, I would point you to the court's decisions in Cook versus Peterson, and then
Cook seems to be directly on point, doesn't it?
Directly on point, Your Honor. And then during the pendency of this appeal, the court went on to decide Hollenbeck v. Berry, 199 AD3D 1329, as well as Kyler v. Sepchik. In both of those cases, similar arguments were made with regards to continuing rehabilitative therapy at home not being a cessation in treatment. In the event that there is no gap in treatment, the defendants have not raised any issues of fact on the serious injury threshold.
Right, but Judge Chacha didn't get to serious injury, right? He didn't address that issue. It sounded like he said gap in treatment. And now, gap in treatment goes to causation, not whether there's a serious injury. But he didn't get to the second part. So if we agree with you on the gap in treatment, wouldn't we send it back to him and then he can consider all these arguments?
Your Honor, certainly you could do that, and I agree with you that gap in treatment is a causation issue. However, I believe that based off of the judge's decision as well as some other aspects of
Your argument is that you made a cross motion that wasn't opposed with an expert affidavit on the issue of serious injury, and so your appeal in this case, you say, not only covers the grant of the motion based on gap in treatment, but also the denial of your cross motion for summary judgment on the issue of serious injury.
That's correct, Your Honor, and I don't remember the case, but all of the facts in the law are in front of this court to make the decision on these issues. And the other thing I'd like to bring up with regards
At a minimum, you would say that your explanation, whether it's reasonable for a gap in treatment, presents a question of fact.
I would parse that a little bit, Justice Curran. I would initially say that there was no cessation in treatment, again, because he testified and the records show that he was receiving medication for his pain and suffering as well as doing home treatment. Therefore, there was no gap in treatment. If we are going to say that there was a gap in treatment, as set forth in the Court of Appeals by Ram Kumar, the explanation would be that this is what he was doing at home. So however the court would like to qualify that, I would say either...
Where the court said that your explanation for the gap in treatment, assuming there was one, was disingenuous, is really a credibility finding that that's not supposed to happen at that stage, correct?
And you said that better than I could when I was trying to offer Justice Lindley an explanation. The one thing that I find a little bit troubling with this when we're talking about sending it back down to the trial court to follow up on these two issues is just that there are certain parts of this decision that, Your Honors, I know how well you read the record. It does not follow what's in the record. He has a longer gap in treatment, alleged gap in treatment. He completely disregards credibility issues with regards to the plaintiff as well as his wife. And additionally, he takes the leap that the plaintiff is doing complete full construction activity with his job when it's very clear from the record that the plaintiff testified at most he was a foreman and he had to make accommodations due to his injury.
Do you think the gap here is 14 months? Is that what you have it at?
I have it.
Talk about 16, but it's really 14, right?
Your Honors, I have it at 11 to 12 months. I point, Your Honors, to the record at 3.
You're talking about the visit on February 6, 2018?
There's actually a visit on February 16th, 2018 at 3:55.
Those were for illnesses unrelated to his back pain, right? He didn't go in there for his back or neck pain.
The primary reason were for illnesses unrelated, Your Honor, but if you look at the prescription list that was issued, they're still issuing cyclobenzaprine and other medication with regards to spasms and injuries sustained to his neck and back.
Okay, so it's 11 months, or at very most, if we don't agree with you on that, 14 months. But
Which respondents actually concede it would be the most in their brief at page number 2.
But they seem to say a couple of things, is that the wife here, which is, she was a registered nurse, and she was at home apparently providing continuous treatment. And they seem to suggest that that's not proper, that's not treatment, she's just a spouse and not a medical, I mean, I'm not sure exactly what all their complaints are, but that is a problem, and also the fact that your client was referred to the Unity Spine Center and he never showed up.
I see both of those issues, Your Honor, and I'll take that one by one. First of all, the failure to follow up with Unity Spine Center, that would be something that would come in for mitigation of damages, as shown that he continued to treat with the primary care and was receiving the medications after that, if that would be an issue. Secondarily, with regards to his wife, yes, she happens to be a nurse, and that makes her a little bit more qualified by regular than maybe other spouses who do not have a medical education. However, still ultimately, this is her confirming that my husband was taking medication and doing home exercises, which you don't have to be a nurse to do.
She's more just of a fact witness, that I saw him doing all these things.
Yeah, absolutely. It's in addition to the fact that she does have the ability to give some credibility from a medical perspective in this.
But this, and the taking the medications and the exercise, that was the course of treatment that was recommended by the primary doctor.
That's right, Your Honor. And again, it's almost directly on point, as Justice Curran pointed out, with Cook v. Peterson. And then, again, it came out after this, but the Hollenbeck decision as well as the Kyler decision with this. And I'd respectfully submit that it would essentially be disavowing those decisions to find that this was a gap in treatment and grant the summary judgment motion in this case.
I think we have your argument.
Thank you, Your Honors.
Thank you.
Good morning, Your Honors. May it please the Court. Jessica Tarrick for defendants, respondents. Your Honors, I'll dive right in with the gap in treatment issue here. Our position is that the gap in treatment is clearly 14 months between the December 2017 primary care visit and the February 2019 visit to a chiropractor in Florida. This is a clear gap in treatment. Plaintiff doesn't seem to even acknowledge this gap in treatment, rather indicating that...
Look, you say gap in treatment, that's a gap in going to see medical providers.
Correct.
It doesn't necessarily follow that he discontinued the medication and the back exercises and whatever he was supposed to do at home. The mere fact that he went to the doctors in between there, that doesn't explain what happened in between.
Well, Your Honor, there's no legal authority out there indicating that simply staying at home, taking ibuprofen, engaging in whatever, self-managed exercises you'd like to.
But it's not really self-managed. This was a course of treatment that was recommended by his doctor. His doctor said, take these, prescribed pain medication and gave him exercises to do. So this was a relatively conservative course of treatment, but it was the course of treatment that was recommended, so.
And respectfully, Your Honor, we would submit that it's not, because the primary care physician said, go to Unity Spine Center.
Right.
Follow up, see what is necessary for these.
So that's your argument, though. Your argument is that he didn't follow up with Unity Spine.
Well, in addition, Your Honor, 2 of the medications were actually discontinued as of February 2018. The prednisone and the gabapentin were discontinued.
Right, but he continued, Palmos talks about a cessation of all treatment. Cessation of all treatment, that's a quote. And it says a plaintiff who terminates therapeutic measures following an accident, terminates. So here you have, didn't take all the medicines, but there was no cessation of all treatment. He didn't terminate anything. He maybe cut back a little bit, but he continued to a lesser degree. So Mr. Ryan says under Palmos, that doesn't apply here, because it wasn't a complete discontinuance.
And Your Honor, to that respect, when there's a situation where a physician directs self-managed at-home care, that's very clear in the physician's notes. And that's, what Cook v. Peterson stands for is, a physician saying, we think that this is all that's going to help you, continue in this course of treatment on your own. And that's simply not what happened here. There was an additional referral to a separate provider that was never followed up on.
I think we have your argument.
Thank you, Your Honor.
Thank you. 210, Timpano versus New York Central Mutual Fire Insurance.
May it please the court. The original motion in this particular action was based upon comparing the facts to whether there was to the actual policy language. It was whether the car was furnished and available for the use by the gentleman that passed. The motion to re-argue started adding new arguments about the language of the explanatory language of the disclaimer letter, whether there were ambiguities in the policy. Those were never brought up during the original motion. Under these circumstances, the motion to re-argue should never have been granted. One of the primary points to show that this was all new language, that these were all new arguments, is that the trial judge asked these new points to be briefed after the motion to re-argument. You'll see at the very end of in the record, there are letters to the judge. Those was a request by the judge for briefing on these additional arguments. Those were never made during the original motion. The responding briefs in this particular case argue that they did bring up the sufficiency of the disclaimer. Well, that's the entire case. They brought that up in only the most vague terms.
So let's get to the merits.
Okay.
Rather than, with respect to the motion to re-argue. Your point is that your client, in the disclaimer letter, relied on both exclusions, both B2 and B3.
They did, yes, it is. They are both based upon furnished or available, those words. And the words or mean or. The arguments against seem to be that it meant and. Or has always meant or in my book. So in this particular case, there is an affidavit from the son that said, yes, my dad had free reign to use this. He didn't have to ask permission. He didn't even have to ask for the keys. Obviously, the deposition testimony was diametrically opposite.
Right, can I just ask you this to make sure I understand this policy? It's a little confusing to me. The exclusion B3 says we don't provide any coverage for maintenance, ownership, or use of any vehicle other than the covered auto, which was the van, not the one that was involved in the accident, which is owned by any family member, that would apply here, because it was owned by a son, or any furnished or available for use by any family member. But then there is an exclusion to the exclusion.
That's true.
That totally vitiates the entire exclusion under 3.
For B3, correct.
Do I have that right?
Correct.
So-
B2 still applies.
I know, B2 is possible, but B3 states an exclusion and then takes it away entirely. Do I have that right?
Under the circumstances of this case, because they had purchased policy limits that were in satisfaction of the exclusion to the exclusion.
So the
Yes.
only way the carrier wins here, the carrier loses under 3.
Correct.
Because 3 isn't an exclusion at all. It's got to be shoehorned, or it's got to be fashioned into 2.
That's correct.
And the only one that would apply would be 2B.
That's
Because
correct.
2A doesn't apply.
Right.
Because he didn't own it.
Right. And
So then it comes down to what was the disclaimer on? Did they, because if the disclaimer was only on 3, then carrier's in a tough spot. But if it's 2 and 3,
And that's why both provisions were listed, all right? If they were only relying upon B3, you wouldn't have seen B2 in the listing.
but did the disclaimer specifically use those numbers, 2A or B or 3? They just use language from them, right?
Well, it uses language, because both are based upon the same type of language, furnished or available.
But it didn't say we're relying on 2B.
It doesn't state that specific, it does say that these are the provisions that we're relying upon, B2 and B3. That's why they didn't say B1 or any of the other ones. They specifically say B2 and B3 are the applicable provisions. The explanatory language certainly focuses more on B3, but B2, it's all the same rationale. This is in place so that, as in this case, the underlying policy is a 25 policy. This one is not. This one's a 100-300. And therefore, they're trying to prevent stacking. And so, the person that has the main policy can get the cheapest one possible because, well, dad's policy will take care of it.
I think everyone agrees that there's an issue of fact as to whether the vehicle involved in the accident was furnished or available for the father's regular use. There's an issue of fact there. Everyone agrees on that?
I certainly agree with it. The original motion, the original decision did. I assume that the other folks have a disagreement about that. Otherwise, they wouldn't have brought the motion. But that seemed to be conceded when we started going into motions to re-argue based upon other bases.
I think we have your argument. Thank you.
Okay, thank you.
Good morning, Your Honors. My name is Paul Hanson. I'm here for the respondent. And it sounds like maybe we can jump right into the B2. The B3 seems to be gone. The question of fact as to use, that's a separate issue. And I think that the court is correct when they're narrowing in on what did that disclaimer say. And if we look at the disclaimer, it says, please refer to your policy definitions and exclusions. And that's where it lists B2 and B3. Please refer to. That's where it starts. Then the disclaimer letter talks about the facts as they see it. And then it says, quote, therefore, liability is specifically excluded for ownership or use of any vehicle other than Yarye's covered auto, which is owned by and or furnished for the regular use of any family member. That's the language of B3. They specifically went out of their way to say this is the reason that we are disclaiming. The fact that they listed B2 above does not say that is why they're relying on that.
If they were relying on 3, it would make no sense to go with 3B, because 3A obviously applied.
Right, and the disclaimer didn't have that however clause that took care of B3. We put that in there, but that isn't the issue. Yeah, no, it just, the disclaimer doesn't meet the test, and the case law is pretty clear that you need a high degree of specificity as to the basis for the disclaimer. Here, at the very least, you have our side seeing it one way, the judge seeing it one way, New York Central Mutual, so it almost can't. They can't meet that burden because now we have people saying it's not clear. And the burden is actually on the insurance company to come forward and they bear the burden of showing the exclusion applies and that it's subject to no other reasonable interpretation. Well, here we've got, I believe, a very reasonable interpretation. So minimally, the confusion would make this letter improper. And I do think that the judge was correct in allowing the re-argument. I don't know if we want to get into that, but I thought there was enough in the record from Mr. Lascarette's motion. He specifically had in his original motion a title, disclaimer letters, and he talks about the difference between you, which is B2, and family member, B3. So it was there, just because the judge didn't zero in on it at the original motion. Credit to her that she wanted more information on the re-argument, and we got to the proper resolution. I really don't have anything else.
Okay, thank you.
No? Okay. Thank you.
211, Britton versus Seneca Meadows.
Good morning, Your Honors.
Good morning.
May it please the Court, Michael Murphy, the defendant appellant, Seneca Meadows, Inc. Your Honors, this appeal involves a motion that no one wants to bring, asking the Court to disqualify plaintiff's out-of-state counsel, Adele and Dubin, and revoke their pro hac admission. But we have a duty to our client, and we're obligated to protect against prejudice our client now faces due to Adele and Dubin's ethics violations.
That's really kind of, in terms of bottom lining it for me, my real question is the question of prejudice. I think you're absolutely correct that there were, and the trial court found a number of ethical violations, and I may even see more, but assuming that we agree with you that there were a number of ethical violations by counsel, I'm not convinced that there's prejudice, because, when we look at a motion to disqualify, we have to always consider the right of the client to have counsel of their choice, which is a very big deal. So if you could address the issue of prejudice.
And I think for context for the discussion, I think we're really talking about the May 4th mass mailing of executable retainer agreements that weren't requested. And the court did, in its findings, say the evidence doesn't show that anybody requested legal services. And there was even deposition testimony and affidavit testimony from 5 local residents saying they received these executable retainer agreements, they didn't request them. And so I think at least that aspect of the record is clear, and I think it zeroes in on the May 4th mass mailing of executable retainer agreements. As to the prejudice, we have to look at the context of the case. The case is a putative class action lawsuit, and it's a different beast than your normal lawsuit. Not everyone who is supposedly interested, if you will, or impacted by the case is actually a party. And that's why you have the threshold decision, which is the class certification determination. And there's discovery.
Well, part of the reason they did what they did is to kind of, in anticipation of class certification being denied.
Yes.
And then they would have this huge group of plaintiffs.
Ready to roll.
Ready to roll.
Ready to roll. And here's the issue. If they had done this somehow, and I don't believe they would have gotten 140 additional clients, but if they had done it ethically, then we have no motion to bring. But they did it unethically. They procured these 140 additional clients unethically.
So you still have to address the question of prejudice.
So the prejudice happens in 2 ways, Your Honor. One is within the structure of the case itself. The fact that my client now is in a position that it could defeat class certification and on its heels is a threat of a mass action lawsuit with 140 plaintiffs, it's a no-win situation. And the only reason it's in that no-win situation is because these clients were procured unethically. Now, none of these additional clients have actually initiated lawsuits. They're just waiting in the wings.
More fundamentally, within the structure of the case, the ABA opinion, ethics opinion 445 is an example. The Court of Appeals NICEG decision is an example. The ability of either party to conduct informal discovery is basically enshrined as a right.
So you're prejudiced because you can't go talk to these people. That's
The only way we
how I
can
understand
now contact these people is through formal discovery, and that's hugely burdensome. And I want you to
But
zero
you
in
were
on.
still able to interview numerous residents.
But that's a misdirect, Your Honor, and I know the other side has pointed to that. Let's just say there's thousands of people within the putative class area. That doesn't mean every witness is equal. If you look at their brief, for example, pages 39 and 40, they get to the merits, and they do this frequently in their papers. And what do they cite? They quote responses to these surveys. They are relying on these specific residents to make their case. If you look at, in the record, Your Honor, I'll find a page, I can't remember it now, but at one point we were requesting, what is the basis for your proposed class? Because they basically drew a circle around, 1.5 radius circle around the facility. And they said, a primary basis for our proposed class are the locations of the residents who responded to our surveys. They've put these surveys and these residents front and center of their case, their affirmative case on the merits and for purposes of seeking the class to be certified. The defendant has a right to discovery with respect to that, to counter their narrative that everybody is suffering the same impact. And now the only option they have is to issue notices of a deposition, hire court reporters, and conduct depositions, instead of just informally contacting.
But get back to all of these interviews that you were still able to do. I mean, dozens and dozens and dozens of interviews your client was able to do. How were you interviewing a different group of people? Did they live in a different county? Did they live 30 miles further away?
There were residents within the putative class area, but they weren't these residents. These are the residents they're relying on. A defendant has a right to defend itself, Your Honor. This is the problem.
So excuse me.
Sorry, excuse me.
What if they only had 5 residents, and you had been able to interview 100 residents? Would you make the same argument?
Well,
because you weren't able to interview those 5 residents?
Well, I'll put it this way, Your Honor. In theory, the answer is the same, because a defendant has that right. It's a vital right. That's what the Court of Appeals describes as. ABA Opinion 445 says the same thing within the class action context. And why should a defendant be required to have restrictions imposed on it to basically undertake a fundamental right, discovery right, because of the unethical conduct of counsel for the other side? That's the basic question.
Well, this prejudice, if we agree with you that counsel, that the firm should be disqualified, that prejudice is going to remain. Because it's not like they'll just get another lawyer. But so it sounds like to deter this type of conduct in the future, you want to disqualify. It's not going to change. It's not going to make things better for your client. It's going to punish the plaintiffs, the potential plaintiffs, and their law firm. And I guess you say that that should be done so that this type of behavior doesn't occur in the future?
Well, it's a good question, Your Honor, because you're kind of really getting at what is the nature of a remedy here. And we believe the conduct is so egregious that it warrants complete disqualification. But Rivera, one of the cases both sides discusses, didn't quite go that far, in fairness. Rivera basically said, we're disqualifying you from representing these additional witnesses in this case. We're not saying you can't continue with the case. So my point is, the remedy, there are different remedies that potentially could be imposed here, but I think if If these folks really wanted an attorney to represent them with respect to this issue, nothing would prevent them from doing the normal thing, which is envisioned under Rule 7.2b, making a specific request, making an inquiry to a law firm expressing an interest in retaining them for that purpose. Those folks aren't foreclosed from doing that, and a remedy doesn't prevent them from doing that. But what we're faced with here is this case, and preventing them from taking advantage of their unethical conduct is what we're looking for.
Thank you.
Thank you, Your Honor.
212, 1640 State Route 104 LLC versus Town of Ontario Planning Board.
Good morning,
You may
Your Honors.
proceed.
Opposing counsel, may it please the court, my name is Robert Marks, and I represent the appellants 1640 State Route LLC and Aaron Preston in this matter. We ask that this court overturn the lower court's decision and determine that the special use permit denial by the Town Planning Board was arbitrary and capricious.
Before you get to the merits, could you just briefly address, there was a motion to dismiss as moot. We deferred on that. They say that the conditions, a lot of the conditions of the Planning Board's site plan approval from November 2018 haven't been satisfied. It's more than 3 years, so it doesn't matter what happens here. Could you address that one first?
Yes, Your Honor. What I want to emphasize with respect to that motion is that the allegations that our clients did not fulfill those conditions are completely outside the record. So any allegations that our clients didn't fulfill conditions relating to that site plan are outside the record. We would have defenses to each of these, allegations regarding those conditions. What we're limited to here is the determination of whether or not the special use permit denial was arbitrary and capricious. And this is an after the effect, after the appeals have been briefed and perfected attempt to try and answer additional facts.
That's usually how cases become moot, things that
Right.
happen later. So, but would you agree that if those conditions weren't satisfied, as they allege, and you dispute, but if they were not satisfied, then you can't prevail in the long run here, your client can?
No, Your Honor. It's wrapped up in the 2020 revised site plan application. And obviously, again, that's also outside of the record here in terms of how our clients have continued to try and receive site plan approval or revised conditions in the 2018 site plan approval.
Okay. So on the merits, you say that your client was given the approval in 2018 to conduct mulching operations, and that it was arbitrary to then later retrench on that in the face of opposition from neighbors.
Correct, Your Honor. It was an absolute situation of where the town planning board succumbed to community opposition after they had already approved it in 2018. And the lower court determined that the 2018 approval was only for storage, not for grinding mulch, not for actually processing mulch. A, it's belayed by the actual language used by the planning board, where they said they can regularly process mulch. But B, it's belayed by the November 2018 hearing, where the planning board members, the town attorney, have a lengthy discussion with appellant's attorney regarding this mulching operation. They refer to it as an operation. They refer to the fact that it's going to be regularly grinding
Right,
mulch.
but the wording itself, you would agree, just the wording, it's ambiguous, because we don't know if they talked about you can store the mulch there to be processed somewhere else, to be mulched somewhere else, or on the property, but you're saying that parole evidence is an offense. If this is a contract, we look at other things to determine what they meant by that. But would you look, the videos and the photographs of this major operation, it's pretty clear. I mean, this is just a massive mulching operation that's going on that's causing outrageous noise for the neighbors, dust that's coming onto their properties, and it's unsightly. And they say that what was approved in November 2018 was far exceeded by what your client then undertook. This massive mulching operation. What do you say to that?
So 2 points. This was not a special use permit approval where they set conditions as to how, this operation should be managed and scaling back. They denied it and repealed prior approvals. So that's point A. Point B, this is a property in a business transitional district. It's a light industrial use. It's permitted under the zoning code to have this. So the fact that the town and the neighbors have issues with the fact that they are next to a business transitional district, it doesn't allow the town or the planning board to spot zone and say, well, we understand you have a light industrial use district, but we're not going to allow you to do that because you're near residential property. But then the problem then is the zoning. It's the zone, what the classification is of the zoning. It's not with our client's operation. It's not with the particularities of whether or not the operation is too much scale. Their issue was they don't want any mulching operation next to this residential property, but it's zoned that way. So there's nothing that can be done about that with respect to the planning board being able to redo a decision be based on community opposition.
Anything further, Council?
I do not believe so unless you have any other questions, Your Honor. Thank you.
Thank you.
May it please the court, my name is Anthony Villani. I represent the town of Ontario. Since council has gone back to the 2018 approval. It says what it says. Obviously, there was a disagreement as to the scope of the mulching that would be allowed. Whether that language could have been better or not is really, we're all stuck with the record that is here. Whether that question was amenable to resolution by the court below on the papers rather than having a hearing on it has not been pursued in the brief. If it's abandoned, we've given you the cases that it's not raised in the brief, it's abandoned.
What about council's point that this is a permitted activity in this zone?
It is. I mean, it's permitted by special use permit. Okay. Now, there's no challenge. There's been then as a result of the legislation, which is not challenged, there's no challenge to the underlying town of Ontario ordinance. It gives certain conditions that have to be met, that harmony, excessive noise, that type of thing. And that's just part of it. So
But that didn't change, right? I mean,
no.
It was part of it when they gave the approval. It was part of it when they changed.
Well, no, I didn't know. No, I don't know that I agree with that, because I think that's the question of what was the scope of what was allowed. The argument and the arguments, to the extent I think you can make a fair interpretation, and again, none of us were there, was that the planning board's position was we gave limited amount of mulching ability. This was a landscaping business. We know that as part of the landscaping, you're going to be trimming trees, you're going to be doing this limited amount of stuff. You're allowed to mulch that.
Right, well, this 2018 resolution said the applicant may store wood stumps, limbs, clippings to be regularly processed for landscape mulch.
Yeah.
The issue is maybe processed somewhere else, but it doesn't say trees.
No,
We have wood
it
stumps,
does not.
limbs, and clippings, and your point is that they brought in thousands of
That's right.
trees there, and that's beyond the scope of stumps and
Yes.
limbs and so forth.
Yes, it became a commercial operation, and in fact, I mean, if you look at what happened, I mean, I've already said, there is no challenge to the finding of the court, or the decision based on the papers without a hearing to further flesh out the record. But if you look at what happened after that, the appellant requested in February of 2020 modified site plan approval to allow for this additional mulching that they wanted. That was turned down on the basis that because this was a commercial operation rather than incidental to the landscaping business, that a special permit would be needed. Again, that finding wasn't challenged. So what finally happens is that they then do apply for a special use permit. That's turned down. It's turned down on the basis of the noncompliance, or the findings of noncompliance with the special use permit conditions set forth in the statute. Again, the statute itself is not challenged. And I think the findings of the planning board are certainly consistent with those provisions. You know, and that's, right, the other argument that is made is that the planning board, in turning down the special use permit, said that we're deleting condition number 2. It was like, you know, whether they can do that or not really isn't before the court, because the court below said the planning board can't do that. All right, because that was, all right, so to the extent that that's being argued, the opponent is really appealing from a favorable decision, which...
Not aggrieved.
I'm sorry?
The appellant is not aggrieved on that point.
Well, okay, but then you get into, now what happened, and, all right. So, but for the motion that is pending before you, the current state of it would be that they do have that same limited ability to mulch that was given in the 2018 approval. But now the problem becomes that the statute says that if you don't get your building permits and you don't get your certificates of occupancy within 3 years of issuance, the site plan is automatically terminated. Now that has occurred, and that has occurred subsequent to the filing of the briefs and the filing of the records. The approval here was November of 2018, so it was November of 2021 that this occurred. In opposition to the motion, the argument was made that, well, some of these violations occurred before the appeals were, or the record was set. Well, and that may be true, but not the termination of the site plan approval by statute did not occur until November of 2021, which was well after the briefs and everything else was filed. So I think that just moots that entire issue. As the dismissal of their 1983 action, I think the case law is clear that in these zoning cases, you don't have the egregiousness that you have that is necessary to support that. Other than that, if there are any questions, I would certainly respond to them. All right, thank you, Your Honor.
213, End of Hill LLC versus Brock Acres Realty LLC.
Good morning, Your Honors. May it please the Court, my name is Chaim Jaffe, and I, together with my colleague Janine Cryan, represent the appellants in this matter. There are a lot of issues in this case that the parties disagree on. We do, however, agree on the most fundamental issue in this entire case, that only a New York State licensed surveyor can determine the boundary lines of real property in New York State. And in fact, Ms. Keister, yes, sir.
I thought the main point was, if I understood it correctly, was that neither the plaintiff nor the witness, Cole, I think is the name, saw any of this happen, so therefore they can't win. I thought that was sort of your primary point on the facts and to why you're entitled to judgment as a matter of law. Am I close?
That is one of the issues, Your Honor, in terms of their argument regarding circumstantial evidence. But I think the most fundamental legal issue, as opposed to the factual issue, that only a New York State licensed surveyor can determine the property line.
But isn't there a question of fact about whether or not there was a trespass by virtue of the fact that you attached to your papers the transcript of the telephone call with Travis, and in addition, you attached to your papers, therefore I think vouching for the admissibility of it, the testimony of the plaintiff, the plaintiff principal. So by attaching all that, did you put in a question of fact here as to the defendant's trespassing over whatever line may or may not be there? He's apologizing on the phone. In addition, the photos show debris that the plaintiff says in her deposition, that's on my property. And you've attached all that to your papers. So I mean, and it's in addition to, you attach the plaintiff's experts' affidavits to your papers. How are we able to look at that and say you came even close to carrying your burden?
Your Honor, all those documents were attached for purposes of, including for Judge Ree in the court below, all of the issues that were before the court on the first summary judgment motion. Okay? The transcripts of the deposition, they fail the best evidence rule. It is undisputed that there may be a cassette of these recordings, and in fact, the plaintiff...
Best evidence rule is irrelevant, correct, to the testimony of an individual who's a participant in the conversation. And you put that testimony into your motion papers.
The transcripts from that conversation were not prepared by someone who had firsthand
But
knowledge.
Van Voorhis, you would acknowledge that Van Voorhis's testimony, this is what he told me, this is what Travis told me, that's admissible evidence, right? Travis called me, Travis said, hey, sorry, my bad, you know, I'll make it right, I'll do this, I'll do that. That's admissible evidence, he's making admissions, right? I mean, we don't need a transcript, they actually have a transcript because it was being recorded, but they don't even need that. You just have somebody says, he told me this. That's admissible evidence, right?
Justice Kern, were you asking me about the purported transcript of the conversation or deposition testimony? Maybe that's where I misunderstood.
I thought he was talking about the telephone conversation.
Yes, Van Voorhis testified in the deposition transcript that you attached to your papers about that conversation. In addition, you attached to your papers the testimony of Cole, who witnessed the damage to the pond and the debris being left on what she perceived to be plaintiff's property. In addition, you attached to your affidavits, your motion papers, the experts' affidavits from plaintiffs on the first motion who concluded that, yeah, there was a trespass and here's all the damage to it. You know that we have to abide by the Court of Appeals with this burden-shifting analysis. So what I'm struggling with, sir, is that when you attach all this, and forget about the best evidence rule, you know, who knows who prepared the transcript of the conversation. You put testimony in a deposition transcript where Travis is apologizing, and to use Justice Lindley's my bad or whatever language was it used, and apologizing for it, I'll make it right. So if we have a question of fact on trespass, then we have a question of fact on the motion, correct?
I respectfully disagree, Your Honor. The issue is Travis Brocklebank may have said A, B, and C, and Ms. Van Voorhis, who was the principal of End of the Hill, may have said D, E, and F. But the fundamental legal issue is, was there or was there not damage to the respondent's property? And in order to make that determination, you first have to establish the boundary lines. The only person in New York State who is qualified to make that determination, Justice Curran, is a licensed New York surveyor. And the only expert in this case, whether it's appellant side or respondent side, is Jeremy Years, who is the only actual licensed surveyor in this action. And Ms. Keister herself says on page 1193 of the record, paragraph 13, she states, only a licensed surveyor can establish the correct location of a property line in New York State, which is consistent with the holdings in 8 James Street, 70 Pinehurst, and Herbold versus LeBaire. And it's undisputed that neither Mr. Eldred nor Ms. Keister are licensed surveyors in this case.
Correct me if I'm wrong. I thought it was undisputed that the defendants at least stored some brush and tree and so forth on Van Voorhis' property. I thought that's undisputed. Now, whether the trees came from Van Voorhis' land is a different issue, but isn't that an undisputed fact in this case, that there was all sorts of things that were left there, and then he removed them after she complained, but am I wrong on that?
I acknowledge that there is an undisputed fact that perhaps there were some rocks.
Trespass onto her land.
Understood, Your Honor. However, that is a big difference between some rocks versus the allegations that there were 1,561 trees. Now, if I may return to the argument, let's assume, arguendo, that there was a trespass. The next question becomes, was it to such a degree that the plaintiff is entitled to treble damages under 861. And that issue, I say unequivocally no. The record is clear that there was probable cause for the Brocklebanks to believe that.
Look,
Go ahead, Your Honor.
your clients knew that they were doing work very close to the property line with a neighbor with whom they did not get along. They knew there were going to be a lot of excavation, they were going to do all sorts of things. They didn't have a survey. They didn't mark the boundary lines with rope, with string. There appears to have been some confusion. They had no survey maps. The person from the county who was there says Travis told them that the pond, or at least part of it, belonged to him, which is wrong. And it just seemed, it was kind of reckless to be tearing down trees. They tore down a lot of trees. Maybe they were their own trees, but to be doing that type of work so close to the neighbor's property without being absolutely sure is negligent at best. It was not reasonable or good faith, it doesn't seem like. At least there's an issue of fact on that.
Justice Lee, I will disagree with you respectfully on that issue. It is undisputed that all of the work in connection with this case, with the digging, took place 20 feet to the north, specifically because the Brocklebanks were aware that perhaps there wasn't the most harmonious relationship between the parties, and they didn't want to get close to the boundary. Now, again, Mr. Years definitively states that all of the work, including the tree removal, took place on the Brock.
How does he know that? He wasn't there when the work was done. Correct? Years comes back years later, right?
4 months, Your Honor.
4 months later, after everything is cleared. But I, like Judge Curran, when I read your brief, from the beginning to the end, it seemed like your main point was nobody saw them take any trees from the Van Voor's property. There's no eyewitnesses, therefore Van Voor's can't win. That is obvious. I mean, there are so many people doing life in prison for murders that were not witnessed by anybody. We have this thing called circumstantial evidence, which the Court of Appeals says is stronger than eyewitness evidence. So that's what they're relying on here.
Your Honor, that's right. All they have is circumstantial evidence, and I'm not saying that's the linchpin to whether or not we're successful or not successful on overturning the lower court in part or in whole. But let's talk about the circumstantial evidence that they do have. They have these photographs, and we go into great discussion in our brief, and we touch on it again in the reply brief, about the unreliability and admissibility of those photographs. There is no indication from Ms. Van Voorhees or Ms. Cole about the timeliness of those photographs. I acknowledge that they indicate, Ms. Van Voorhees indicates that either she or someone in her presence took those pictures. But there's no indication when they were taken. Were they taken the day she first recognized that perhaps there was damage on her property? Did she take them months after, like she tries to do with respect to her photographs in support of the spoliation argument, which I will get to in a moment? So they have that in terms of circumstantial evidence. They have the infamous piece of string that was tied between the two property stakes that Ms. Van Voorhees clearly acknowledges that she and a friend tied between the two stakes that Mr. Van Voorhees had, that Mr. Years had placed in 2008, who the plaintiff used when she purchased the property. So in 2008, she relies on Mr. Years for the accuracy of his work so she can purchase her property. And then in 2014, when there's this issue, and Mr. Years comes back out and says, the string wasn't straight that the plaintiff tied, and the work and all the tree removal took place on the Brockacre side, all of a sudden, Mr. Years' opinions are not good.
So is it your position then that we should disregard that circumstantial evidence as a matter of law? I mean, these all sound like great arguments to make to a jury.
Thank you, Your Honor. I think as a matter of law, Your Honors are capable of determining whether or not the photographs and the videos, which are part of the circumstantial evidence, pass an admissibility test as a matter of law. I think that you can do.
Well, Van Voorhees said in the affidavit that they fairly and accurately depict certain of the conditions created solely by defendants on plaintiff's property. She links those photographs to the damage inflicted on her property by your clients.
That's what,
That's the timing.
but when, Your Honor? When? Was it the day the trees were removed? Was it months after that? When?
Questions at trial.
Okay. Let's talk about the pond, if we may, for a few minutes, Your Honors. The as-is built drawing of the project that nobody contests clearly shows all of the work was done at least 20 feet north of the property line. It shows that there are no pipes, no drains anywhere on the respondent plaintiff's property, and there are certainly no pipes in the pond. Now, Mr. Eldred, their licensed engineer, goes to great lengths in his expert affidavit, his supplemental disclosures, to present far-fetching, broad strokes description of what he thinks could be some damage. However, there is nothing in the record, and they have presented nothing to talk about what the pond looked like before the work, what it looked like after the work. There's no indication that he did any investigation to see if there were any pipes in the pond or anywhere else on the plaintiff's property. And they don't deny the as-built. There are no before or after pictures. And the Jenkins case, which we have cited several times in our brief, is directly on point with respect to the pond. We talked about the pictures and videos. And the other piece of circumstantial evidence, Justice Lindy, is this Exhibit 8A that undeniably was prepared by Ms. Van Voorhees and Ms. Cole at the direction, perhaps, of their expert, Ms. Keister. It's not scientifically accepted within the community. It was the back of the napkin drawn. And that was also some evidence that, again, they were lying. So they have the pictures and photos, Justice Peridotto, which this court can rule on as a matter of law. It can rule on the fact that the string was not straight, as determined by the only person in this case qualified to make that analysis, Mr. Years. And there is significant case law in our brief that the Exhibit 8A sketch is not accepted in the scientific community and does not represent evidence on which an expert should be able to base his or her opinion.
I think a lot of these questions go, do they affect the admissibility of the evidence or the weight at trial? And that's something we'll have to look at.
Counsel, you have now exceeded your time limit, so if you'd like to wrap up.
Just again, our briefs are significant. There's some significant issues raised in our brief. I did not touch on all of them. They are important. I thank you for your time and courtesy in reading all of our papers.
Thank you.
Good afternoon now, Your Honors. Warren Rosenbaum for the respondent plaintiff, if it please the court. There's an awful lot in this case.
You would fundamentally say, Mr. Rosenbaum, that there are tribal questions, material fact, and that the defendants do not carry the burden on their motion, correct?
Absolutely. I mean, I'll answer any questions the court has, but I wanted to just address a couple of points that Mr. Jaffe had mentioned and some of the members of the panel had asked him about. First of all, it's a red herring that we don't have dates on these photographs, because as appellant's counsel well knows, he has all those dates. If you look at the end of the transcript of Ms. Van Voorhees' deposition, where Mr. Jaffe is going through one by one, and there were hundreds of photographs that Mr. Jaffe wanted to go through one by one to ask Ms. Van Voorhees what date were they taken. And we both agreed on the record, and it's at page 697 of the record. I'm sure the court has or will research the record. We both agreed that Mr. Jaffe would propound interrogatories with respect to each photograph, and Ms. Van Voorhees would answer the same under oath, which she did. And unfortunately, it's not part of the record, whether it's an oversight on my part or Mr. Jaffe's part is irrelevant. We've got interrogatory responses that are almost 100 pages long that list every single photograph, and the first question that Mr. Jaffe asks in his interrogatories with respect to each photograph is the date that each photograph was taken. So the fact that they are saying in their brief now, based on the record, that, gee, we don't know what dates these photographs were taken, respectfully, it's outside the record, I understand that, but I think it's a disingenuous claim under the circumstances. I agree that the question of the admissibility of these photographs and the admissibility of tape recordings and so forth, those are all issues that will be resolved at trial based on whatever record is made at the time of the trial. The presiding judge at trial will make those evidentiary rulings, as all of your honors, I believe, have been trial court judges, know very well. The survey business is really a complete red herring. Nobody's disputing where the survey boundary line was. The fact of the matter is my clients knew where the survey boundary was. The problem was that his client didn't know where the survey boundary was and didn't pay no heed to where the boundary was. Can you imagine the Soil and Water Conservation District devises this plan to do work adjacent to a wooded area and doesn't even bother to ask for or get a survey. They looked at aerial maps, aerial photographs, and Mr. Hafley, who was with Soil and Water Conservation District, admitted it gives you a rough idea where the boundary lines are. Well, a rough idea doesn't cut it when it comes to trespassing on somebody's property. So, Your Honor, I think a lot of these things go to the weight, and the admissibility is going to be decided at trial. There's plenty of evidence in admissible form, or which can easily be admitted into evidence, that justified Judge Reed in denying the motion for summary judgment. Classic case of disagreement of experts. We've got conceitedly 2 qualified experts with respect to the forestry issues. We've got Ms. Keister, who gave her affidavit and her report information, clearly qualified, nobody's disputing she's qualified, who testifies based upon evidence that she observed herself and which she customarily relies upon in rendering opinions such as this, that there in fact was trespass, there was a crossing of the boundary line, and a lot of trees were knocked down. And this handwritten drawing that appellants worry about or complain about was done under the direction of a certified forester.
Counsel, Mr. Jaffe talked about spoliation. And
I'm going to talk.
You're not seeking any sanctions on spoliation. You were just using that as an explanation for why your client doesn't know exactly how many trees were taken down, because they were taken down by his client and they took them away. You're not seeking any sanctions or any?
I'm not seeking any sanctions, Your Honor, but we may ask the trial judge for a charge on that issue, depending upon what the proof shows concerning spoliation. Our case has been certainly compromised from the get-go by the removal of the trees and their later destruction. And whether they were all taken away and destroyed immediately, as seems to be alluded to by the appellants, or whether they were taken away and destroyed over a period of time after my spoliation letter was given to them in January, I think of 2014 or 2015, we don't know. And the proofs at trial will presumably flesh all that out. And if it's appropriate for the court to give a spoliation charge, we'll argue about that at trial, and the court will give the spoliation charge, and the jury will do what the jury does. In any event, Your Honor, based on your questions and based upon the presentation today, I'm confident the court has got a very good handle on this case, and I'm very pleased to have been able to argue this case before you this afternoon. Thank you for your time.
Thank you. 214, McGurr versus Shiflett. Good afternoon, you may proceed.
Good afternoon, Your Honors, and may it please the Court, Jason Telak here on behalf of the appellant, William McGurr. I'd like to begin by addressing the issue of constructive notice. After the deck collapsed in this case, the defendant hired a gentleman by the name of Meehan to come out and tear down the collapsed deck and to replace it. And Mr. Meehan was an experienced carpenter. He had many years of experience. He's the only person who is arguably an expert in this case, and his testimony is undisputed. Mr. Meehan testified that the deck collapsed because it lacked flashing, it lacked lag bolts, and it lacked support posts. He also testified that these issues would have been visible and discoverable before the deck collapsed. Now, the undisputed evidence in this case...
So let me just interrupt you, though. As I understand it, this deck, the defendant had hired someone, I want to say like in 2014, to put lattice up, so it would have, the defendant would have had to remove that lattice in order to discover this, right?
That's correct, Your Honor.
Because that's how the post-accident person discovered it. He took off the lattice, and that's when he discovered the, I guess, the cause for this collapse.
That's correct, Your Honor, but the defendant herself was the one who had the lattice installed, who would have concealed these defects from view, and the lattice was
She didn't know she was concealing defects. She was she was asking someone to put lattice, and before that, there was no indication that there was a problem with the deck. And the lattice was put up, what, I don't know, 4 years before the accident happened, right?
Yeah, it was put up approximately 5 years after the deck was constructed. So there was still a 5-year period where there was no lattice, where these defects would have been visible and apparent upon a reasonable inspection. So there was still, sufficient time to see these defects before it was imposed.
What, was there anything during that 5-year period that would have triggered the need for the defendant to go under the deck and do such an inspection?
Well, the defendant never did do the inspection. She never hired anyone to supervise the alleged gentleman who apparently built the deck. She never hired anyone to come in and do periodic safety inspections. The defendant and her husband were the only ones who would come through in between tenants and look the property over. She called it fluffing during her deposition testimony, where she would look to make sure the property was tidy. But she didn't do any type of formal safety inspections of this property, and she was renting it to members of the public. She was deriving a financial benefit from operating this as a commercial property or a rental property, and she did nothing to ensure that it was reasonably safe. And she had a non-delegable duty to do that, which I will address here in just a moment. But on the issue of creation of these defects, the defendant, she admits that the deck was built after she purchased the property while she owned it in 2009. She claims that she hired some gentleman to build this deck for her, but she's provided no information whatsoever about who this gentleman was. And she is the only person who knows the identity of who built this deck. It's in her exclusive knowledge and control. And her testimony that someone else did it, blame someone else, is entirely self-serving. And it creates an issue of credibility that a jury should get to listen to. They should get to hear her on the stand talk about, well, I hired a guy who I don't have any information about, but it's his fault, blame him. That should be allowed at the time of trial, so a jury can weigh her credibility and determine whether or not it's worthy of belief. And even if she did hire an independent contractor or a third party to build this deck for her, she still was responsible because she had a non-delegable duty to keep the property reasonably safe because she was renting it to the public.
So you're saying she's vicariously responsible for the conduct of the independent contractor?
Even if we assume that there was an independent contractor, she would still be vicariously responsible, correct?
How do you assume there wasn't an independent contractor?
Well,
is there any proof that she didn't build the deck herself, right? She hired someone to...
That's a credibility determination. That's based solely on her testimony that I didn't do it, someone else did, but I can't provide you any information about who that other person was. But assuming that a jury finds that worthy of belief and believes that there was an independent contractor, she would still be vicariously responsible because she had a non-delegable duty to keep the property reasonably safe. Because she was renting it to members of the public, she was inviting people onto the property, she was benefiting financially as a result. And
if she was not renting to the public, would you be able to make the same argument?
I think if this was
I mean,
purely.
if this was purely her personal home, purely used for her personal use, and she had a friend to come over for lunch and the deck collapsed, would that be a different, would your argument, would you have the same argument?
So whether there's a non-delegable duty, it's a sui generis.
No, I'm
yeah,
not talking about that. We know about that.
It would change the calculation
Whether there's vicarious liability.
for
There's at
an
least a
independent
third.
contractor,
Right.
correct. That would change the calculation, but that's not the factor. The fact here is that she was inviting people on, she was renting the property, she was earning money from it, and she had a non-delegable duty. And also, this deck was the primary means of ingress and egress into and out of this property. And so she had a non-delegable duty to make sure that this primary means of ingress and egress was reasonably safe for people coming onto the property. Another reason she was vicariously responsible is because she failed to prove as a matter of law that she was not negligent in selecting, instructing, and supervising the gentleman who built the deck, assuming that there was a gentleman who built the deck for her. She admits that she didn't supervise any of the work. She didn't really do anything. There was no inspection after, there was no permit. She didn't do anything to make sure that this deck was built reasonably safe. The only thing that she said was the gentleman who built the deck told her that he was experienced.
Well, Meehan said that the deck was stable, that other than, where the legend board or, where it attached to the house, that other than that, it was a well-built deck. It was stable. It was in good condition.
Meehan said that there were some parts of the deck that were built properly, but there were parts of the deck that weren't built properly, and those were
The attachment was the problem.
Exactly, where the deck failed and what caused the incident that we're here for was not done properly.
And counsel, tell me of the permit, the lack of a permit, would that have made a difference?
Well, if there was a permit or an inspection, that could have provided an opportunity for someone to realize and point out the fact that this deck was not built up to code, it wasn't safe, it
Whose
wasn't built properly.
responsibility is the permit?
Well, I think as the property owner, she is ultimately responsible because she has a duty to make sure that the property is reasonably safe, especially knowing that she's inviting people onto the property.
And if she hired somebody to build that deck and they didn't get a permit, is she still responsible?
Ultimately, yes, because the duty is non-delegable.
Well, again, Meehan said he didn't see anything that would amount to a code violation, didn't he?
I don't believe that was Meehan's testimony. Meehan testified that flashing is required by code.
Page 243 of the record.
I don't have that in front of me, Your Honor, but my recollection of the transcript was that he said flashing is required by the code. And he also talked about the other.
We're talking about the deck itself, not the attachment.
Okay. I mean, the attachment point where the deck meets with the house where it failed, right?
Yeah, we know that's the issue.
Right.
How about your res ipsa argument? You make a res ipsa argument.
Yes, Your Honor. So there are, three prongs to the res ipsa argument. That a deck does not ordinarily collapse outside of negligence, whether it be negligent construction, inspection, or maintenance. I cited the case in my papers, point for that. And point two, that the defendant remained in exclusive control of the deck. Here, it's undisputed, she owned the property when the deck was constructed. She owned it continuously throughout the time that the deck collapsed. And the exclusive control requirement doesn't mean that she has to have the property to herself that entire time. It's not interpreted that way, just that if there is negligence or if there's a defect, that she is the one who should be responsible for it. And that is the case here. She would rent the property out for 1 week intervals, but after the 1 week was up, she would retake the property, she would walk through it. It was at that time when she had the duty to look for and identify any problems with the property. So she never relinquished exclusive control for the purposes of res ipsa loquitur. And then for the third prong of the test, there's no evidence in the record that the plaintiff did anything wrong to cause or contribute to the defect. So I think the third prong is satisfied as well. So unless there are any additional questions for me, I will rely on my papers.
Thank you.
All right, thank you.
Good afternoon. You had wood mulching, you had trees, and now you got the finished product, a deck. I think I was paying attention. I think the important thing to understand, Judge Perodato and Justice Winslow, is you have, if you look at the testimony, Mr. Meehan, the flashing goes behind the siding. The deck attaches to the ledger board. The only thing that's visible that would be an apparent mistake in the way it was constructed was, what he said was there were nails used instead of bolts. And in this case, to suggest that a layperson would be able to appreciate that there was some problem with the way the deck was constructed in light of the fact that there had never been any complaints about it.
So let me interrupt you, Mr. Bond. I asked a couple of questions about a permit, and that would be the introduction of somebody who's not a layperson, who would come in and say, you know, hey, this deck looks great, except it's not attached properly, so put the bolts in there, and then we're all cool, all right? But that's not what happened here, is it? I mean, that was a mistake that plaintiff never, or the defendant didn't discover, but in fact, it did cause a big problem here, and if you go way back, it could have been remedied by the defendant following the law, which required a permit, you know, and it's a step that lots of people skip over, you know, but here it caused the problem.
Well, Judge, the response to that is what Mr. Meehan said, which is the reality of the circumstance, that when people get a permit, sometimes the permit guy comes by and says, looks good to me. He would have had to affirmatively get under the porch to look. And what he said was, whether the inspector would have done that or not, we don't know. So there's nothing in the record to confirm what your assumption is, that the inspector would have done that.
That's true. There's nothing to show that, you know, if he went under there, he would have found this. But they didn't invite that kind of inspection.
Right. And so I guess the question becomes, is it negligent to hire someone to build a deck who doesn't get a permit? Or does that fall on the homeowner, which is just a person, you know, which is a lay person who doesn't particularly understand the construction requirements, which gets us back to, you know, in today's day and age, is it negligent to hire someone off of Craigslist or through the home finder where they found Mr. Meehan to do the work? And is it reasonable for someone to rely upon someone who's advertising to tell you what they need to do to construct the deck and to rely on them to do the right thing?
I suppose the permit issue, it goes to constructive notice. It
Well,
arguably goes to constructive notice.
It could, but I don't think the
Could go to
plaintiff has raised or presented in the record any affirmative proof that the permit would have addressed this problem or solved this problem.
How about the vicarious liability?
Vicarious
Very
liability, if you look at the
interesting.
cases cited, you know, there's a Court of Appeals case where the construction is ongoing and it's a landlord. And the other two cases are large commercial establishments where they talk about means of ingress and egress to the general public. You know, that's not really what we're dealing with here.
No, it's kind of it's a smaller scale.
It's a
but,
smaller scale, but, you know, I don't know that, you know, again, in today's day and age, if people are renting on Airbnb and
Right.
VRBO, are you all of a sudden taking this property owner and imposing upon them some heightened duty that wouldn't apply to an individual homeowner? I don't know the answer to that. You know, it's an interesting question because there is
It's a
some
very interesting question.
financial benefit there. But the fact of the matter here is, if you look, you know, there was no complaints. There was no complaints about the deck. It's unlike in Hoffman versus United Methodist Church, where they said it was obvious. If you looked, you could see the deterioration. Here, the average person looking wouldn't know any better. And it was only after the deck collapsed, when Mr. Meehan came in and said the ledger board was rotted. In fact, there's no proof, because the ledger board was rotted, there's no proof that even the bolts would have made a difference because of the fact that the wear and tear and the writing of the wood.
Black bolts in the rotted wood aren't going to do you any good.
Yep, once it's rotted, it's rotted. So unless there's any specific questions, I'll let you get on to your next wood case.
Thank you. 215, Pierce versus Medeski. Good afternoon, you may proceed.
Good afternoon, Your Honors, and may it please the Court. Rebecca Izzo of Connors LLP, on behalf of defendants appellants Dr. Thomas Medeski, Dr. Dale Sponigal, and Radiology Solutions Associates, PLLC. The crux of the plaintiff's allegations against radiologist Dr. Sponigal and primary care physician Dr. Medeski is that upon becoming aware of a possible empyema on a CT scan ordered by surgeon Dr. Mazziti, it was not enough for Dr. Sponigal and Dr. Medeski to have their office staff contact the surgeon's office staff. According to plaintiff, the doctor should have gotten on the phone directly with Dr. Mazziti that day and made sure he was aware of the results.
I think part of their argument is that you should have called the patient and told him that there was a problem.
Yes, that is part of their argument as well, but that, Your Honor, is outside the duty of both of these two doctors. So a radiologist has two limited duties: interpreting scans and documenting the findings. Here, Dr. Sponigal did two tests, a barium enema and a CT scan. There's no dispute that on both of those tests, he correctly interpreted the scan and documented his findings. And there's also no dispute that those findings were communicated to both the primary care doctor and to the ordering physician.
And they were communicated because he found them to be disturbing enough that he wanted those doctors to know right away. And it may have been equally as important for the patient to have some inkling, and that's part of their allegations against you as well.
That is part of the allegations as well. And as the ordering physician, it was in the duty of Dr. Mazziti to be in charge of the care of the patient, including any communication with the patient. The duties of Dr. Sponigal and Dr. Medeski in the circumstances of this case were limited and did not include that contact.
All right, so you confused me a little here.
Sure.
Okay? You start talking about the radiologist not having certain responsibilities, and now you're talking about another doctor, the primary care physician who started this whole ball rolling, who received all this information, who also didn't share it with anybody.
So let me address the primary care physician. The primary care physician referred the patient to Dr. Mazziti, the surgeon. That referral occurred in September 2014. Now, Dr. Medeski, the primary care, did continue to see the patient for workers' compensation, but the investigation of the possible bleeding.
It went past that. It went past that, and there was this other finding that, oh my gosh, there's something else going on here.
Correct.
Okay, and Dr. Medeski learned about that.
Correct.
So what I kind of see here is all of the healthcare people knew about it. The only person who didn't know about it was the plaintiff.
That's correct, Your Honor. However, again, it's whose duty was it? And our contention is that it was the duty of the ordering physician, the physician who was in charge of the care.
Who was that?
Dr. Mazziti, the surgeon, who is the other appellant. The primary care, once it's referred out, is not responsible for interfering with the care of the surgeon who's the specialist.
Is notifying the plaintiff that he really needs to address this issue interfering?
Well, here's the issue, is that it's not that simple. So the CT scan, what it showed...
Yeah, and maybe, excuse me for thinking that it is that simple, okay? That findings like this that are, well, we know now, okay, that they were life-threatening, okay? They were serious, and the guy died not very long after all this, without ever knowing, that doctors knew that this could be a consequence of him doing nothing, okay? So, all right, so you say it's not your responsibility, either of your defendants, and they're going to get up here and tell me it's not their responsibility either. So isn't that a question of fact? Who's responsible?
No, it's a question of the duty, which is a question for the court. And with the primary care physician, once the care is referred to a specialist, they're not supposed to second guess and interfere. And here's something that's important. When the surgeon ultimately reviewed the scan, his determination was that it was not an infection. Now, that turned out to be false down the road, but at the time, that was his determination. It was up to the surgeon to make that determination. It was not up to the primary care doctor who had referred to the surgeon to read the scan and determine whether or not the quote-unquote possible empyema was in fact
Okay, so
an
the other
empyema.
diagnosis might have been cancer,
Yes.
He didn't call it cancer doctor either. I mean, in other words, there just seems to be no follow-through here, and the consequence was that the plaintiff died. And maybe at trial, when you stand before a jury and point fingers at each other, they can decide, okay? But on what I saw here, there's questions about all of their responsibilities to the plaintiff, who was all of their patients.
Two answers to that, Your Honor. First of all, the primary care doctor, Dr. Medeski, did take action. He had his staff call Dr. Mazzidi's staff to ensure that Dr. Mazzidi was in fact taking care of it. And he was told that they were. So he did take that step. With respect to the radiologist, again, the duty is very limited. They don't treat the patient. They don't see the patient. The duty is to read the scan and to document the findings. And Dr. Sponigal did both of those things and even went above and beyond to make sure that the appropriate doctors had that finding in a timely manner.
Ms. Izzo, when you're ready, I'd like to take you to your alternative contention at page 30 of your brief.
Sure.
This has really piqued my interest.
Sure.
If I understand it correctly, point 3 says that you're seeking summary judgment dismissing allegations in the bill of particulars not addressed by plaintiff's internal medicine expert, correct?
Yes.
So basically, if I understand it correctly, you're asking the court to grant you partial summary judgment with respect to those allegations in the BOP, not specifically addressed by plaintiff's expert.
Yes.
Isn't that directly contrary to our case in Abatoy versus Kurz in 2008? And I've got the case here, where it says exactly to the contrary. Defendant's contention is based on a misperception of the function of a bill of particulars. The expert affidavit from the plaintiff did this, did that, contrary to defendant's contention. Plaintiffs were not required to submit an expert opinion with respect to each allegation in the bill of particulars. That's what we said.
Well, Your Honor, I think in Bubar, the court said that that is what needs to happen.
Well, in Bubar, we didn't contradict Abatoy. We didn't address it at all, correct? So are you saying that Bubar changed the law in this respect, or no?
No, I think we're saying that under Bubar,
But how do you deal with Abatoy? Because that was always the law. I did med mal, I think, for 6 years on the trial bench, and lawyers would cite this as being the contention. Are you saying that Bubar has somehow changed the law so that we're now going to allow partial summary judgment of allegations in a bill of particulars? Is that your contention?
No, Your Honor.
Okay.
That's not our contention.
I realize there's language there, just to be fair to you, Ms. Izzo. I
Yeah.
see what you're talking about. But here's my concern on that. So this was all handled in a post-decision posture with letters between lawyers.
Yes.
This is included, this isn't included. And the judge made a decision, and you're objecting to, I think, 3 or 4 allegations with respect to Dr. Medeski, whatever his name is. So can you envision a situation where the court may have to take proof over whether the plaintiff's expert affirmation encompasses the allegations in the bill of particulars? And what happens if some of it is dismissed as part of summary judgment? Then at trial, plaintiff's experts testifying about this, that, or the other thing, objection, it's been stricken from the bill of particulars. Are we going to have voir dire of the expert of what this means? We've already said the expert doesn't have to track the language of the bill of particulars in opposing summary judgment. So I envision this whole Bubar process that you folks followed here to be kind of almost in a weird land. I mean, is this what's happening in the trial courts?
I mean, my understanding is that it is, under Bubar, that each allegation in the bill of particulars needs to be addressed by, as a prima facie case, and then needs to be
But isn't that really in
rebutted.
the context, I mean, you didn't move for partial summary judgment. This doesn't even come up until your reply papers. You don't ask for 3212G relief to establish uncontroverted or established facts. So the plaintiff is there not knowing that you're looking for this relief necessarily. Well, in fairness to you, it doesn't come up until you get the expert affidavit. I get that.
Right.
So I see that point, but, I mean, Blue Bar cites to a case called Donna Prince, something like that. And in that case, it was where we said the plaintiff hadn't addressed a cause of action on appeal, therefore it was deemed abandoned. This is one cause of action, negligence. And all 3043 of the CPLR says, for bill particulars and a personal injury action, is general allegations of the acts or omissions claimed to be negligence. So now we're supposed to parse those general allegations. And by the way, are we supposed to do this in every personal injury case? So this is what I'm struggling with. Do you have any answers for me? I'm sorry to go on so much, but
No,
it really struck me as weird the way this unfolded after the court had made its decision. Lawyers go work it out. Well, sometimes lawyers don't do that.
I do understand your concern, Your Honor.
How do we deal with this?
And I don't have a good global answer for you on that, but I do rest on our brief on that issue. And if I may address causation before I sit down. There is a key issue here with causation, rather the lack of causation with respect to Dr. Sponigal and Dr. Medeski, which is with respect to the allegation that they should have made sure that Dr. Mazziti knew about the CT scan. Even if he had known, the result would have been the same. Because when he saw that CT scan, his professional opinion, his medical opinion based on having seen the patient and having examined the patient and looking at the radiology scan was that it was not an empyema, it was not an infection. And so whether he'd gotten those results several days earlier or not wouldn't have made a difference.
Okay, it was something though, right? He found something.
Yes.
And whether it was an infection, okay, which I understand would be less likely than what he thought it might be, which was some kind of a tumor or some kind of cancer. Didn't that still require some immediate action and on the part of Mr. Pierce's physicians, all of them?
Well, that's a question on the negligence side, Your Honor. But on the causation side, the plaintiff needs to show beyond mere speculation that it would have been different if the doctors had taken the actions that...
Wait a second, Ms. Isn't it enough under our case law to show that it deprived the plaintiff of a better outcome, the possibility of a better outcome? Isn't that enough? I think we have cases, Clune versus Moore and others, that talk about, in terms of causation, all you need to do is deprive the plaintiff of a possibility of a better outcome, correct?
Correct. But here my point is that based on the conclusion that the surgeon, Dr. Mazziti, had when he read the scan, nothing would have been different if Medeski or Sponigal had given him that information in a more sooner, because the result would have been the same. He would have come to the same conclusion. And again, whether or not that was should have been done.
What you're telling me, this is what I feel like you're telling me, okay, is that, presented with all this information from his physicians, that possibly Mr. Pierce might have decided, I need some clear answers and go someplace else. Like, in other words, in light of the lack of consensus about his treatment here, or even what he was suffering from, he might have sought the, help of a more capable group of physicians.
But there needs to be more than hindsight reasoning on causation and speculation. There was a bad outcome here.
We're going to ask plaintiff's attorney all these same questions, so I don't feel like I'm, picking on you.
And thank you for taking the time this late in the day to be patient with me here. But they need more than hindsight reasoning. They need more than there was a bad outcome, and from the position of 20/20 hindsight, something different should have been done. The plaintiff's expert here didn't say when they thought the infection started, when it should have been diagnosed, what would have been different if, again, focusing on my clients, the radiologist and the primary, if they had gotten on the phone and let Dr. Mazziti know of the results earlier.
Okay, and that's still not even what I'm thinking is their claim, which is not that you should have talked more, but you should have talked to them more. That's what I hear their claim being. So thanks, counsel.
I understand. If your honors have no more questions, I would ask you to reverse. Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court, Kate Hartman for Appellant Defendant Dr. Masidi. I have a feeling you might have some questions for me. Our main point in our brief and on this appeal is that there was never any challenge that we met our initial burden, and that we feel the plaintiff's expert, the general surgery expert affidavit that was submitted was inadequate to raise a question of fact on the
So who
issue.
should have told the plaintiff that he maybe had some life-threatening disease?
They
say it's you. I mean, not you personally. Your
Yeah, Dr. Masidi, when he...
Answer my question. Who should have informed plaintiff that he had a possible life-threatening condition that needed immediate care?
I think it was the people who had the results as soon as they received.
So you think
them.
it's them? They
And
thought it was
a
you.
primary
Okay.
You're surprised at this answer, right?
Yeah. I mean, it was somebody. I mean, I can't imagine that plaintiff didn't deserve to know, okay? So, I mean, and I think that's a given. Plaintiff deserved to know that there was a big problem here. He learned pretty quickly thereafter, but they say you should have told him, that they ceded care to you. Do you see that way?
Your Honor, I believe Dr. Majeski as the primary care physician and having more of an overarching view of Mr. Pierce's health and having the results of the CT scan might have been in a position to speak with Mr. Pierce about it.
Gotcha.
And part of the issue here too is, and why it's our position that the general surgery affidavit was inadequate, is because the expert doesn't acknowledge that Mr. Pierce was asymptomatic. There were questionable results on the radiology, but when he was seen on January 27th, and then the CT scan was January 30th, and then he didn't start showing symptoms until the morning of February 1st. So when Dr. Masidi saw him on the 27th, he asked about pulmonary symptoms. There was no coughing, there was no shortness of breath. He listened to his lungs and they were clear, so he wasn't exhibiting any of the telltale signs that there was a lung infection at that time. And the overall, his history and the smoking habits and everything is kind of what led him to believe, in his training and opinion, that the mass was more indicative of something like cancer and wasn't necessarily a lung infection. And his expert doesn't address the asymptomatic nature of Mr. Pierce at that time, or state that a lung infection can exist absent those symptoms and didn't subsequently develop. And while he received the results of the imaging on February 3rd, it's not like he didn't also receive any contact from plaintiff or from Mr. Pierce that he had additional symptoms or his condition had changed. So when he was reviewing it, it was based on condition of Mr. Pierce at that January 27th visit, and thinking, and that kind of influenced his interpretation. If there are any questions, I'll rest on my brief.
Thank you.
Thank you, Your Honor.
May it please the court, Patrick Maloney representing Deborah Pierce and Justice Perodato. Just for the record, I've had this case for 4 years and I still get Meduski wrong most of the time. First, two things. One, it's our contention, they didn't shift the burden. They did not eliminate every material issue of fact, which is exactly what the trial court held. The trial court said, we don't know who said what to whom. And right here we have the same argument. Meduski and Sponagule are saying, no, it was Masidi's fault. Masidi is saying, no, these guys got the information. They're the ones that said that, that they had the information. Unless they've eliminated every material issue of fact, I could rest. I won't, but I could, because they have not shifted the burden. Somebody in their brief says on 702, I concede this point, page 702 of the record. If you look at 702 of the record, my point says, in addition to the questions of fact concerning the medical treatment, there are also questions of fact surrounding Mr. Pierce's care and treatment and the events leading up to his death. First, we have the communication. Secondly, we have Dr. Masidi saying, well, it's not an infection. I would have seen things differently. Well, that's a question of fact based on the record. Lastly, the point that Dr. Masidi's attorney just brought up about Mr. Pierce's health the day before he went into the hospital. They say he was fine. Mrs. Pierce does not. Mrs. Pierce says he was deteriorating, and obviously it's a question of fact that needs to be determined by a jury. I've got, as it appears, I am the last thing between you and lunch.
That's okay.
I will be brief. I have just a couple more points to make.
Your time.
Could we ask you to address the causation question?
Yes.
That was raised?
For them to argue that an infection was not present when Mr. Pierce appeared at the time of the CAT scan just is not correct. First of all, it's present on the x-ray. The empyema is seen there. He says possible empyema. Well, the radiologists say a lot of stuff is possible, but he says also when he was questioned, importantly, at that time they knew it wasn't a malignancy and it was an infectious process. He then goes on to say that the pleural effusions are infection. The empyema is, by definition, pus between the lining of the lungs and the interior. It is infection. It was present, it was seen, it probably was there 2 weeks earlier when they saw the mass, which is another question that the jury needs to decide, and it was confirmed when he went to Buffalo General that it was an empyema. It was confirmed on the death certificate where it says multi-system organ failure due to septic shock due to or as a consequence of empyema. Also, the very first thing on the autopsy is organizing empyema with adhesions in the right lower lung. It was there at the time. It was so significant that Dr. Sponagule said he needed to call these people. They needed to be aware of it. And that's where we get into the duty, ladies and gentlemen. I'm sorry, I think I'm talking to a jury. Sorry, Your Honors. That's where we get into the duty. This was a potential life-threatening situation. An empyema in the lung of a man who's been a long-time smoker is potentially a life-threatening situation, and no one told the patient.
Who should have told your patient?
All of them. First of all, Dr. Sponagule, and the other thing is, the counsel has said that plaintiff is claiming. Plaintiff isn't claiming. Plaintiff's 3 board-certified experts are claiming that this is what should have occurred. And they also addressed the proximate cause issue, saying because it didn't occur, he wasn't hospitalized, he wasn't given IV antibiotics, and that the empyema wasn't treated, which led to his death. So they also addressed the proximate cause issue. There is no question that there was an infection present, had been there for some amount of time. Essentially, when you talk about all the cases and everything that's cited in their brief, and essentially just the arguments that they were making, they're saying, well, my experts are better than your experts. Well, that's not the standard. The standard is, have you eliminated every conceivable issue of fact? And in this case, they have not. I will then move to the last refuge of all defense counsel when they, in a malpractice case, when they say that they have moved, that plaintiff's experts are vague, not based on the records, and therefore conclusory. If you look at the experts that I have submitted, I have 3 different experts. The first is internal med, board certified, 35 years experience. He references 30 different medical records or testimony. He references the medical records or the testimony 30 different times in his deposition. He lists 12 separate and distinct deviations from accepted care. The next one is the general surgeon, also board certified, 30-plus years experience. He makes 40 references, specific, distinct references to the record. He lists 8 separate, distinct deviations. Radiologist, board certified, 30-plus years experience, 25 references to the record, and 12 separate and distinct deviations from accepted standards of care. These were detailed expert affidavits that looked at the records and determined that there were deviations. Lastly, in this question about the duty of the patient, they say, well, I'm just a radiologist, I don't have a duty. I'm just a general care physician, I don't have a duty. First of all, let's go to the primary care physician. The primary care physician always has a duty to his patient to inform him of a life-threatening, potentially life-threatening condition. And in this case, it's the condition that killed him. To say, oh, I handed it off to Dr. Masidi, well, first, that's a jury question, but secondly, it's not true. The primary care physician is in charge of the overall condition of the patient, always. You get consultants, Masidi is a consultant, but all of Masidi's tests go to the primary care physician. The primary care physician oversees all of it. And also, in this particular case, Dr. Meduski himself said, well, I'm calling Dr. Masidi to make sure he handles it, but if he didn't handle it, I will handle it. We will take care of it. That was his testimony. If Dr. Masidi doesn't take care of it, I will be happy to take care of it. So to say that he doesn't have a duty, first of all, defies common sense, and secondly, defies the record. Also, these doctors themselves set the duty. They tried to contact someone to make sure this was taken care of. My experts say they didn't do enough. They had to contact the patient. They had to speak directly to the doctor because of the extraordinary nature of what was found on the x-ray. They did not find what they were expecting. Dr. Sponagule says, we now know it's not malignancy, it's an infectious process. He was so concerned about that, he called, or had his secretary call the 2 doctors, but the secretary-to-secretary communication is what my expert says is not appropriate. When you have a potential life-threatening condition, you need doctor-to-doctor communication. That didn't occur, and it was below accepted standards of care.
Mr. Maloney, just a 20-second answer here to Judge Curran's line of questioning about the Bubar situation.
I'm glad you asked, Judge. You're asking for a whole load of trouble if you decide on this. Bubar, that's what's happening at the trial court, Judge. Defendants are using Bubar to say if my expert they're essentially reversing Ebony. And they're saying if my expert doesn't specifically address each and every allegation, it's gone. And my understanding is that was not what the Bubar decision was meant to do, but that's what it's being used for. In this particular case, interestingly enough, this isn't a case where Bubar wasn't considered. Bubar was considered. The trial judge said, all right, you guys try to work it out. What you can't work out, submit orders. I will take a look. And he ruled on it. You guys are busy enough as it is. Why you would want to get involved in looking at that decision would open up exactly what you're saying.
Can you envision there might be a hearing to decide what's in and what's out?
Absolutely.
And then you see the complications that cause the trial.
Yeah.
And what about Avatoy? That was always what was argued before.
Right. With all due respect, these are decisions that should be made at the trial level. I mean, the trial judge is the one, you guys were all trial judges, that has the handle on everything that's going on, to bring these things up in the appellate level. And the other aspect of it, and I may be a little jaundiced, but the defendants themselves essentially had their own affidavit. They submitted their own affidavit, and essentially what they did is took every allegation in the bill of particulars and said, I didn't do this. It's not like they had to go out and get, I don't want to say a real expert, but they didn't get an outside expert. All they did was say, look at the bill of particulars, say, I didn't do this. Now I've got to fight that. And then we have a further fight about, well, you didn't address 7, 10, and 15.
And if all you did was mimic what you said in your bill of particulars, it would be conclusory.
Right. Thank you.